ceremonial ramp and offer flowers to Preamble and Constitution of India. I kindly request all the chief guests to take a seat on the dais. Good morning to one and all present here. Honorable dignitaries on the dais, distinguished guests, respected advocates, I extend a warm and respectful welcome to each one of you to the inaugural ceremony of Lawyers Training Program organized by Bombay High Court Kolhapur Bench Action Committee under the guidance of Justice Shri Karnik sir. I would also like to thank and extend a deep sense of gratitude to all the judges of the Bombay High Court for their continuous efforts towards enhancing the standards of the circuit bench of Bombay High Court at Kolhapur, the bar, and promoting and encouraging advocates from the six districts, especially the junior advocates, to be part of this very prestigious institution. As a token of our respect and gratitude, we would now like to present a small memento to our honored guest. I kindly request Advocate V.R. Patil sir, conveyor of Bombay High Court Kolhapur Bench Action Committee, to felicitate Lordship Justice Shri M.S. Sonak sir. I now request Advocate Sangram Desai sir, Member Bar Council of Maharashtra and Goa, to felicitate Lordship Justice Shri M.S. Karnik sir. I request Manisha Satputri Madam, Lady Representative of Kolhapur District Bar Association, to felicitate Ladyship Justice Sharmila Deshmukh Ma'am. I request Advocate Ashok Wagmode Sir, President Sangli District Bar Association, to felicitate Lordship Justice Shri S.G. Chapargaonkar Sir. I request Advocate Sambhaji Rao Moite Sir to felicitate Lordship Justice Shri Ashwin Bhobe Sir. I now request Advocate Shivaji Rane Sir, ex-President Kolhapur District Bar Association, to felicitate Advocate Narendra Walawalkar Sir, Senior Counsel, Bombay High Court. I now request Advocate Vivek Shukla Sir, DGP Kolhapur, to felicitate Honorable Principal District Judge Shri Mati Kavita Agarwal Ma'am. To commence this ceremony, I would like to invite Advocate V.R. Patil Sir and Advocate Sangram Desai Sir to deliver the welcome speech and formally greet our dignitaries and the audience.
Good morning, everybody. At the beginning of this program, I salute Honorable Justice Bhushan Gavi Sahib, Chief Justice of India, and start my welcome speech. The dignitaries on the dais, Honorable Justice M.S. Sonak Sahib, Senior Judge, Bombay High Court, Honorable Justice Makarand Karnik Sahib, Administrative Judge, Bombay High Court, Kolhapur Circuit Bench, Honorable Justice Sharmila Deshmukh Madam, Judge, Bombay High Court, Kolhapur Circuit Bench, Honorable Justice Circuit Bench, Kolhapur Circuit Bench, Honorable Justice A.D. Bhobe Sahib, Judge, Bombay High Court, Honorable Advocate Narendra Walawalkar Sahib, Senior Counsel, Bombay High Court, Honorable K.B. Agarwal Madam, Principal District Judge, Kolhapur, the Mr. Sangram Desai, Member of Bar Council of Maharashtra and Goa, and all the lawyers present here. Firstly, I welcome all the dignitaries on the dais and off the dais. On behalf of Bombay High Court, Kolhapur Bench Action Committee, the Bombay High Court, the functioning of Bombay High Court Kolhapur Circuit Bench is started on 18th August 2025, and I am happy to say that as per my knowledge, in the first month, more than 1,000 cases have been disposed of, and more than 1,000 cases, new cases have been filed in the circuit bench of Kolhapur. Since beginning the circuit bench in Kolhapur, the lawyers from our 6 districts are observing the functioning of circuit bench. However, it is necessary to get acquainted with the practice and procedure of High Court. We show our readiness and requested Honorable Justice Karnik Sahib to conduct the training programs for lawyer, and Honorable Justice Makarand Karnik Sahib supported and our initiatives for conducting the training programs. Today, we are inaugurating the training program at the auspicious hands of Honorable Justice Makarand Karnik Sahib, Honorable Justice M.S. Sonak Sahib, and Honorable Advocate Narendra Walawalkar Sahib will address our lawyers on High Court practice and procedure. And I am sure that the lawyers from 6 districts will definitely get benefit of their guidance, and they will hugely participate in the proceedings of Bombay High Court Kolhapur Circuit Bench and do their best to get the justice for the litigants. Today, the training program is inaugurated in Kolhapur. We will arrange the training programs in other 5 districts also, that is Sangli, Satara, Ratnagiri, Sindhudurg and Solapur, so that maximum lawyers from 6 districts will confidently practice in the Bombay High Court Kolhapur Circuit Bench, and hope for the best support and guidance from the bench and bench for training programs. I would like to thank all the dignitaries on the dais for their best support and guidance for our training program. Thank you very much.
A very good morning to all the present here. Honorable Justice M.S. Sonak sir, Honorable Justice Karnik sir, Honorable Justice Sharmila Deshmukh ma'am, Honorable Justice Chapalgaonkar sir, Honorable Justice Ashwin Bhobe sir, my senior and guru Shri Narendra Walawalkar sir, the Principal District Judge of Kolhapur Agarwal ma'am, the President of Kolhapur District Bar Association and the President of Action Committee, Mr. V.R. Patil sir, all my friends, the Honorable DGP, and all the seniors present here. We know why this function has been arranged for, as V.R. Patil sir has already explained to it, the thing, why this function has been held. But I would like to, tell you a few things which happened behind the back, which many of you may not be knowing. Being youngsters, maybe some of you have participated in the agitation which took place earlier, like 35 years back. So many of you may not be knowing that. So I just don't want to tell you exactly what happened in these 35 years. But there is one important thing which is connected to today's program. And this is the last incident I remember. We had requested for a meeting with the Honorable Chief Justice of Bombay High Court. And Honorable Chief Justice of Bombay High Court had given an appointment to us. And the then President, Mr. Khoth Shah sir was present. And we were supposed to give a presentation to Honorable Chief Justice of the Bombay High Court to convince him that a bench at Kolhapur can be established. And in that morning, almost 20 lawyers from across the 6 districts had come to Bombay. We were sitting in the Bar Council of Maharashtra and Goa, and we were discussing how we are going to convince the Chief Justice of Bombay High Court to establish a bench at Kolhapur. And I'll speak a little bit in Marathi also. Many of the lawyers who were there, many of them would not be in a position to speak in English. So we were planning की आता आपण चीफ जस्टिसना कसं कन्व्हिन्स करायचं, कोणी बोलायचं, कशा पद्धतीने बोलायचं, आपले शब्द चुकले तर त्याचे परिणाम काय होतील, असं आमचं एक खूप डिटेल डिस्कशन तिकडे झालं. अँड फायनली थोडंसं मी आणि शहा सरांनी बोलायचं असं त्या दिवशी ठरलं. आणि कंटिन्युअस मला फोन येत होते सगळे लोकांचे की सर आज चीफ सरांबरोबर आपली मीटिंग आहे 4 वाजता, काही करा पण ते चीफ सरांना तुम्ही कन्व्हिन्स करा. म्हणजे जणू काय असं मी जाऊन सांगणार आणि चीफ सर कन्व्हिन्स होणार अशा पद्धतीत फोन यायचे. आणि स्पेशल कोल्हापुरी टोनमध्ये फोन यायचे ते मला, सर काय पण करा, काय बी करा, पण ते साहेबांना तेवढं कन्व्हिन्स करा. एक जण तर मी म्हटलं काही काळजी करू नका, आपल्याला सगळं यावेळी चांगलं परिस्थिती आहे. नाही म्हणाले ते मुंबईवाले लय गंडी होत्यात. म्हणजे आणि मी हे सगळं डिस्कशन चालू असताना माझे इतर बार काउन्सिलचे मेंबर, मुंबईचे काही लॉयर्स, तर कोणाची नाव घेणं बरोबर नाही, बट दे वर सिटिंग देअर अँड दे वर लिसनिंग टू ऑल व्हॉट वॉज हॅपनिंग अँड दे वर लुकिंग टू अस इन अ व्हेरी फनी वे. लाईक म्हणजे असे गावातनं लोक येतात ना की ज्यांना काहीच कळत नाही आणि असे बडबड करतात नाही का, तशा पद्धतीत ते आमच्याकडे ऑब्झर्व करत होते. झालं, आम्ही 4 वाजता चीफ सरांकडे गेलो. वी हॅड अ वंडरफुल मीटिंग. आय मीन वी कॅन हॅव अ राऊंड ऑफ अप्लॉज फॉर शाह सर. त्यांनी अप्रतिम प्रेझेंटेशन दिलं, अप्रतिम प्रेझेंटेशन सरांना दिलं अँड सर वॉज व्हेरी हॅपी विथ दॅट प्रेझेंटेशन. सोनक सर वॉज देअर इन दॅट मीटिंग इफ आय रिमेंबर करेक्टली. येस, ही वॉज देअर. आणि ती मीटिंग झाल्यानंतर मी खाली येत होतो आणि अनायासे बॉम्बेच्याच एका ज्युनियर लॉयरनी मला मॅटर ब्रीफ केलं होतं, बेलचा आर्ग्यू केलं, बेल अलाव झाला. तो क्लायंट आणि तो लॉयर आला आणि मी घाई उबर बुक केली होती आणि पळत पळत जात असताना तो क्लायंट आणि लॉयर आला, म्हणाले सर फीज आणली आहे. म्हणून ती फीज त्यांनी मला दिली, मी माझ्या खिशात ठेवली, मी बघितली पण नाही किती, आणि धावत धावत खाली गेलो. तिथे सकाळी बसलेले काही बार काउन्सिल मेंबर्स आणि काही लॉयर्स तिकडे मला खाली भेटले जिन्याच्या इकडे. म्हणे अरे एवढ्या लवकर मीटिंग आटपली तुमची? म्हटलं हो आटपली. सांभाळून जा पडेल. मला वाटलं खिशामधले पैशांबद्दल बोलतं, असं ते बल्ज आला होता. तर मला असं वाटलं की ते खिशामधल्या पैशाबद्दल बोलतो आहे. तर म्हटलं नाही रे, व्यवस्थित ठेवलं आहे. नाही म्हणाला 40 वर्षाचा लढा आहे, खूप दिवसांनी मिळालं आहे, खिशातनं घेऊन चाललं आहे. मग माझ्या लक्षाला म्हणे अरे खंडपीठ मिळालं ना तुला, खिशात घेऊन चाललं आहे. दिस वॉज द लेवल ऑफ फन पीपल वेअर मेकिंग ऑफ अस in those days when we were trying for the circuit bench at Kolhapur. My dear friends, it's a very humble request की लोकांनी कुठल्याही अर्थाने बघितलं असेल, but I took it very positively. People making fun of us to see that we are trying to see that a bench is established at Kolhapur. We all converted that negative energy into positive energy and convinced ourselves, no matter what happens, we'll see to it that there is a bench at Kolhapur no matter what, and we all did it together. Lordship Justice Gavai sir, all the lordships over here, everybody has supported us. Karnik sir has a very special role to play, had a very special role to play in this, and we should again clap for Karnik sir also. Without him it wouldn't have been possible. Now after this has happened, in last a month or so, whenever I used to meet Karnik sir, he keeps on telling me that all the lawyers from Bombay who used to practice there in Bombay and appear before me are still coming and appearing before me. Where are those lawyers from Kolhapur who aspired to be good lawyers from Kolhapur? Where are they? And all these 4 judges sitting here, they keep on asking me. And that's how this idea came up. Lordship Justice Karnik sir, ma'am, everybody, Chapalgaonkar sir, Digesh sir especially, the other day he met me in the train, he was telling me the same thing. Everybody said that we want young lawyers from all these 6 districts who would come and practice before us. And that is what we intend to do. My dear friends, please, if at all somebody is making fun of you because maybe you're not good in English, maybe you're not good at choosing words, maybe you don't know the procedure, perfectly fine. Just listen to these great people. From them, you'll understand how and what the practice and procedure is in High Court. It's not a rocket science that you will not understand, but you will have to concentrate, you will have to do some hard work. When I say hard work, I don't mean you have to actually do some काहीतरी सामान बिमान ओझं वगैरे न्यायचं, असं hard work नाही येते. See, if you love something, it's not hard work at all. You know, if it's your passion, you will just enjoy it. So all those who have come here, there are a selected few who have come here, and I truly believe that it is your passion to practice in the High Court. So just listen to these great people, understand. If you have any queries, ask to them, but see to it की पुढच्या 6 महिन्यामध्ये आपल्याला निदान असे 100 वकील लॉयर्स तयार करायचे आहेत जे स्वतःहून हायकोर्टमध्ये या 6 जिल्ह्याला रिप्रेझेंट करून प्रॅक्टिस चांगली करतील. असे 100 लॉयर तरी आपण पुढच्या 6 महिन्यात करायचं, एवढं आपण आज करू. आय अगेन थँक ऑल द डिग्निटरीज सिटिंग ऑन द डायस दॅट दे हॅव स्पेंड लॉट ऑफ टाईम. म्हणजे आता ज्यावेळी आपण सोनक सरांना ऐकाल, मी मुद्दाम जास्ती काही बोलत नाही, मंत्रमुग्ध होणार. सरस्वती ज्यांच्या जिभेवर असते ते सोनक साहेब आपल्यासमोर आलेत आणि आदरणीय नरेंद्र वालावलकर साहेब ज्यांनी आम्हाला प्रॅक्टिस कशी करायची हे शिकवलं ज्यांच्याकडनं, असे 2 मोठ्या व्यक्ती आपल्याकडे आले आहेत. खरं तर जस्टिस भोबे सगळेच जण महान व्यक्ती आहेत. कधी ना कधीतरी आपल्यासमोर ते वेगळ्या रोलमधनं येतीलच डेफिनेटली. सो आय विश यू ऑल द व्हेरी बेस्ट अँड थँक्यू व्हेरी मच सर.
Thank you, VR sir and Sangram sir. I now request Honorable Principal District Judge Kolhapur to address the gathering and share few words.
Very good morning to all. After introductory speech and the pains taken by all our senior advocates from Kolhapur and grand support from higher judiciary, from Apex Court and Honorable Bombay High Court, your dream has come true to have a circuit bench at Bombay. I once again congratulate to all of you, and I think all of you, all the aspirants would be taking this opportunity, golden opportunity of today's training to strive hard and to represent all the 6 districts. Good morning to Honorable Justice Shri M.S. Sonak on the dais, Honorable Justice M.S. Karnik sir, Honorable Justice Sharmila Deshmukh madam, Honorable Justice Shri H.G. Chapalgaonkar sir, Honorable Justice A.D. Bhobe sir, Senior Advocates Narendra Walawalkar sir, Advocate Shri Sangram Desai, Member Bar Council of Maharashtra and Goa, Advocate V.R. Patil sir, President of Bar Council of Kolhapur. It is my privilege to extend a warm welcome to your lordships on this advocate training program. Your lordship's gracious presence is a source of great inspiration to all of us. This program is designed to strengthen professional skills and ethical values among advocates who are indispensable partners in the administration of justice. We are confident that your lordship's guidance will enlighten and encourage the participants to strive for excellence in their practice. On behalf of the district judiciary, I once again extend my respectful welcome to all the dignitaries. Thank you.
I now request Lordship Justice Ashwin Bhobe sir to address the gathering.
Good morning. Honorable Justice Sonak, Honorable Justice Karnik, Honorable Madam Deshmukh, Honorable Justice Chapalgaonkar, Shri Honorable Walawalkar sir, Honorable Madam CDJ, Justice Sangram Bosle, all the dignitaries present over here, members of the bar, and all my friends. First of all, congratulations for having a circuit bench in Kolhapur. And secondly, it would be my privilege, and also I would feel that you all would have the occasion to hear the dignitaries present over here. Justice Sonak, who also happens to be from the state which I am, that's Goa. And as said by Mr. Sangram Singh, after the speech, we would like to hear what Mr. Sangram Singh has said would be the truth about Justice Sonak. Not less is Justice Karnik. The speech or the manner in which he deals with the bench, treats the bar members, exception. It's an exceptionally good judge we have. I would take the occasion to say I had the opportunity to argue before Justice Karnik. Obviously, I had argued before Justice Karnik, Justice Sonak also, but Justice Sonak is a little closer to Justice Karnik. Exceptionally good judge. And anybody you can ask, Mr. Sangram Singh would bear out. One of the most favorite judges who had taken the occasion to sit in the state of Goa, the most lovable judge. Justice Deshmukh, I did not have the occasion or privilege to appear before her, but an exceptional good judge and a very good person. That's my personal experience. Justice Chapalgaonkar, I know him a little, but from the manner, the demeanor which he treats his colleagues and the members, exceptionally good person. Mr. Walawalkar, I just learned about him, and I also heard Mr. Sangram Singh to say he is guru and a very esteemed member of this bar. I would have the privilege to hear him today. Madam PDJ, I have not known you, so I cannot say anything about you, but I certainly would see from the crowd that you are one of the best. And now the presence of all you makes the occasion more special, because the number in which you all are present, I hardly see any seat vacant. So obviously you are the best, and you will get the most, the guidance from the best sitting over here. So please take the opportunity. And as Mr. Sangram Singh said, that we want 100 members or 100 advocates to now come up and practice in the High Court. And obviously what he missed is that some members to obviously take the role what we are sitting, what we have taken today. So we would like to see some of you be in our place in the near future. So without taking much time, I am also blessed today to hear Justice Sonak and Mr. Walawalkar, so I will not take much time of yours. Thank you very much. And last,
I now request Lordship Justice Chapalgaonkar sir to address the gathering.
Good morning, everyone. Honorable Justice Sonak, Honorable Justice Karnik, Honorable Justice Deshmukh ma'am, Honorable Justice Bobe, Senior Advocate Walawalkar sir, Principal District Judge Agrawal madam, संग्राम देसाई सर आणि आपले लाडके अध्यक्ष पाटील साहेब. मुद्दाम मी मराठीमध्ये सुरू केलं कारण एवढंच आहे की मला वाटतं मी बेटर वे कनेक्ट करू शकेल आपल्याशी. आणि आपण जिल्हा न्यायालयामध्ये मोठ्या प्रमाणावरती मराठीमध्ये आर्ग्युमेंट्स करत असतो, त्यामुळे हायकोर्टामध्ये आपण काहीतरी वेगळं करायला लागतं असा समज असतो, तो दूर व्हावा म्हणून मी मराठीमध्ये सुरू केलं आहे. तर जास्तीत जास्त कोल्हापूर आणि या 6 जिल्ह्यातल्या तरुण वकिलांनी हायकोर्टामध्ये येऊन प्रकरणं चालवावीत, एवढ्या एकुलते एक भावनेने आम्ही सर्वजण इथे आलो आहोत. आणि पुढच्या 10 वर्षामध्ये आपण जे माझ्यासमोर आज आहात किंवा इतर जिल्ह्यातली जी तरुण मंडळी आहेत, यातनंच आपण सिनियर ॲडव्होकेट्स होणार आहात, यातनंच आपण जजेस पण होणार आहात आणि कोल्हापूर बेंचचं नाव आपण वरती घेऊन जाणार आहात. या लेक्चर सिरीजमधनं आपल्याला हायकोर्टमधली प्रॅक्टिस प्रोसिजर ही लवकरात लवकर अवगत व्हावी आणि आपण आत्मविश्वासानं हायकोर्टामध्ये कामकाज सुरू करावं, या उद्देशाने ही लेक्चर सिरीज आज सुरू होते आहे. मी कोल्हापूरच्या बार असोसिएशनचं आणि कमिटीचं खास या निमित्ताने अभिनंदन करतो. आणि सुरुवातीलाच लेक्चर सिरीजच्या आपल्याला सोनक साहेब आणि वालावलकर साहेब यांचं मार्गदर्शन मिळतं आहे, यापेक्षा मोठी सुवर्णसंधी असू शकत नाही. त्यामुळे ही लेक्चर सिरीज नक्कीच खूप सक्सेसफुल होणार आणि यातनं जो आपला उद्देश साजरा होणार याबद्दल मला नक्की खात्री वाटते. आता जास्ती न बोलता मी माझे 2 शब्द संपवतो. आपल्या सर्वांना लवकरच आमच्यासमोर आपण ॲपियर व्हाल, वकील म्हणून मला दिसाल. काही चेहरे दिसत आहेत इथे येणारे, पण अजून तेवढेसे दिसत नाहीत. तर नक्कीच तुम्ही याल. तुम्हाला वेलकम करण्यासाठी आम्ही आहोत. कुठलीही भीती न ठेवता या, आर्ग्यू करा प्रकरणं. कसली अडचण असेल तर आम्ही त्याला मदत करायला तयार आहोत, एवढं आश्वासन देतो आणि माझे 2 शब्द संपवतो.
I now request Ladyship Justice Srimati Sharmila Deshmukh ma'am to share few words.
Dignitaries who are present on the dais and off the dais. I actually had some personal commitments. I was not supposed to come here. But then a writ was issued by Justice Karnik that you have to come here. Which writ I had to obey, and I'm here. And I'm very glad that I'm here. Because then I get to hear Justice Sonak, whom I had appeared on many occasions, Justice Karnik, before whom I had appeared on many occasions. And they are the kind of judges who used to support the bar. And I am sure even the judges who are coming here at the Kolhapur circuit bench will be the judges who will support the bar. It was our dream that when we are sitting on the circuit benches as the first judges, we wanted to see unfamiliar faces. And we are now slowly seeing those unfamiliar faces who come with a lot of confidence. आणि लँग्वेज इंग्लिश लँग्वेज जरी कोर्टाची लँग्वेज इंग्लिश असेल तर इट इज ओनली अ मीडियम ऑफ कन्वेईंग वॉट यू वॉन्ट टू से. वी डोंट एक्सपेक्ट यू टू बी शेक्सपियर. कोणीच नसतं. लँग्वेज फक्त तुम्हाला कायदा माहिती पाहिजे, लँग्वेज नाही. तर तुम्ही कायद्याचा जास्त अभ्यास करा. प्रॅक्टिस प्रोसिजर हे सगळं आपण शिकणारच आहोत. जे तुम्ही सगळं जे स्वप्न बघितलेलं होतं सर्किट बेंचचं ते आता सध्या ब्लॅक अँड व्हाईट आहे. त्याच्यात कलर तुम्ही भरायचेत. द यंग मेंबर्स ऑफ द बार ते चित्र तेव्हा पूर्ण होणार when we see all of the young members of the 6th district who come with pride and argue before the High Court with confidence. Even why even the 6th district? When I was presiding at the principal seat, many juniors who were from this different district, I never saw them come forward with confidence and argue matters which today they appear before me and they argue with confidence. And I'm so proud of this bench, of the dream that you people have seen, which gave opportunity to so many people to argue before the High Court who were actually lost in the principal seat. So make the most of this opportunity which you have. And I will tell you just a little bit about my journey. I did not come from any legal background or something. Destiny brought me to this profession as a lawyer, and I didn't know anybody. I was not from any senior advocates chamber. I did not have any legal background. But when I joined my seniors chamber and तिकडचे जे senior advocate, somebody like Mr. Walawalkar, senior advocate, I have observed him in courts, how he used to argue. And whatever those senior advocates used to tell me, like once a senior advocate was asking my senior about me, how is she doing? And my senior being very kind, she said, yes, she's on the way up. So I said, no, I'm quite an average person. So he said, mediocrity is not a crime, laziness is. And this is what you need to imbibe, hard work and a passion for this. It is only that hard work. Everybody is not born intelligent. Somebody may grasp something in maybe one hearing, somebody may grasp it in 2 hearings, somebody 3, somebody 4. Somebody may take a long time of maybe reading it for the 11th time, but you should have that capability of putting in that kind of a hard work where you are able to read it for the 11th time and grasp it. And believe me, there is no stopping you if you put in that hard work. And even if the Bombay lawyers are practicing over here, I'm sure whoever are there are very eager to mentor you all. And this training session is a very wonderful initiative which has been taken. So at least you will get a little bit habituated to the practice and procedure. But believe me, it is not the practice which matters. It is not the language it matters. It is not the confidence that you show in the court that matters. It is only your knowledge of law which matters, which you have to keep on upgrading. I'm sure when you hear Justice Sonak and Mr. Walawalkar, what we learned watching them, you would also be learning watching them. And one thing, just a piece of advice to the young lawyers, mostly when you're sitting in the court now, don't be on the mobiles. Hear arguments, try to grasp whatever is there. You will learn a lot when you're sitting in the court. That is your learning ground. So don't waste time on mobiles, unless you are of course researching or something, but usually we see like मैटर नहीं निकल रहा है तो चलो मोबाइल पे चैटिंग करेंगे ये फ्रेंड को कौन सा मूवी देखा कहाँ गए. नो, court is a learning experience. So every minute, I would say I was practicing for 27 years. Every day that I left the court, I learned something new from the court and I went back. That should be your attitude. That every day when you leave from the court, you should learn something new and leave the court. And don't leave the court before that. And I'm sure that we will see a lot of senior counsels and judges from this crowd which is there. And we hope all the best for this circuit bench. Thank you. Thank you so much.
I now request Lordship Justice Shri Karnik sir to give an inaugural speech for the function.
My senior brother, senior colleague, Justice Mahesh Sonak, Sister Sharmila Deshmukh, Brother Santosh Chapalgaonkar, Brother Ashwin Bhobe, Senior Advocate Shri Narendra Walawalkar Sahib, Shri Patil, the President of this bar, Bhobe Vaini, Desai Vaini, Walawalkar Vaini, Sangramji, Shah Sahib, all senior advocates here, my dear junior friends, everybody who is present here, eagerly wanting to hear Justice Sonak speak. And well, we came here with some apprehensions. 45 years of struggle, 45 years of aspirations. Sagram just said what kind of journey they had to face to get this circuit bench, what struggles they had to face. And well, we also had an apprehension on coming here that, well, it's a very, very new challenge for us. And thanks to His Lordship, the Chief Justice of India, Justice Bhushan Gavai, and all those who supported in this endeavor, our Chief Justice, now the Supreme Court Judge, Justice Aradhe, and the administrative committee judges, the judges of the Bombay High Court, my colleagues, who all were very, very supportive for this cause. After 45 years of long struggle, within no time we have this bench, and all of you are a part of history now. Well, when I came, I said there were apprehensions, but after I came to this hall and I saw the plaque where it is written, Kolhapur sa law katta. You know, this word katta is so dear to everybody's heart, right from college times to the court times. Katta brings a lot of closeness, proximity. And well, it is at this katta that we'll see this circuit bench grow. Well, we are very fortunate that we have before us, and when Sangram came, when our senior advocate Shah Sahab came, I said ki we have to, there need not be any anxiety amongst the junior lawyers. Well, there's not much of a difference. You are already well equipped. There are, when we came here, well, Kolhapur, Solapur, Satara, Sangli, Ratnagiri, Sindhudurg, we all knew that there are at least 10 or 12 lawyers in every of these district, in every taluka bar, who can compete with any of the High Court lawyers. This has been the history of these 6 districts. And all those lawyers who have now come here to practice are dear friends. They are very close to me. I am from the appellate side bar. All those lawyers have come, they are amongst you. Only thing is they have been there for 10 years, 15 years, 20 years. And it is from here that they learnt the basic lessons of law. So it's not as if they have suddenly condescended from some heaven or something. All of us have to go through that struggle. And therefore, if, to put it very simply, I don't want to go much into it. Justice Sonak will be telling you, and I thought Justice Sonak is the best person to start today's inaugural. It is because of his sheer, I'll tell you, the mannerisms, the etiquettes which he carries. 24/7. You will never find him, you know, whenever he greets you, he meets you, you see the warmth and the, you know, his mannerisms is so immaculate that sometimes we wonder we are so harsh. And that is what has to go into every lawyer, the kind of respect he gives to the bench. I'm talking Justice Sonak as a lawyer. Well, we have all seen him as a judge. But since we are here for you, you must know what Justice Sonak was as a lawyer. Well, I've been told by Justice Oak and so many of the judges there in Goa that Justice Sonak, Ashwin tells me that, well, Ashwin followed his footsteps later. But then when Justice Sonak was on leave for any reason, the board would collapse. Such was his standing, such was his practice. Is it that Justice Sonak talks in a very loud tone? You'll find him talking very softly, gently, with respect. And that is what a good advocacy is all about. It's about impressing a judge. It's about arguing for your client. It's not about raising your voices. It's about persuasion. And that is what goes into a good lawyering. Apart from everybody will tell you, come prepared, come do this, do that. But tact and advocacy skills is something that you must learn from him. Now about Justice Bhobe, well, I was in Goa, and I must tell you that Goa is very close to Kolhapur. It's just 3.5 hours from here. And I would urge Justice Shah, Justice Sangram, Sindhudurg is very close, that many of you must visit the bar in Goa. It's a treat, even as a judge when I sit there. Well, it was a treat. I had this fear of going to Goa purely because the Goa bar is regarded as one of the best bars after the Supreme Court and after the Bombay High Court. So therefore, I initially had an apprehension, but Justice Sonak gave me a lot of confidence not to worry, hear them. As such is the level of the senior counsels there. It has got so many, it's an array of good senior counsels you have. Even amongst the middle level counsels, well, Justice Bhobe, he said, well, I was kind to him, but just this morning he was telling me that I was very rough with him. And he reminded me in those 9 months, I didn't give him a single order in his favor. So my apologies, I didn't know Justice Bhobe was to become a judge. I'm very sorry, Justice Bhobe. But this is how it is. We decide cases against you. We don't know what we have decided, but we only know that a lawyer has argued very well. As a lawyer, he was top class. I just don't know how many lawyers I have decided in whose favor, who have I decided against. What we remember is a good argument. That is all that we remember. And just remember, before a court of law, the real pleasure is in arguing a case, not winning or losing. Leave it to the judge. You don't have to bother about that. So this is how it is in the field of law. To put it very simply, we are today here to switch over. Many of the seniors want to switch over from the trial court practice to a high court practice. There are juniors who want to now start a new practice in the High Court. So we'll be looking at two things. And then there are already established lawyers who have come from Bombay, from the Sikh districts, who are doing very, very well. They are excellent lawyers you have. Like my sister said, they are the ones who will mentor you. Please go up to them. They'll teach you what the best practices are. And I can tell you, to put it very, very simply, well, it's like this. Previously, as judges, we were given this white Innova car. Now, the Innova car that we have is with gears. Now, we are used to driving an Innova car with gears, loud noise of the engine and all. And then comes the change. We are given these modern cars, which is an automatic car. Now, the very first day, a switch over to the automatic car, I thought I'll drive this car. And, well, I never drove an automatic. I sat on the driver's seat and started to push the button. There was no noise of the engine. And I was trying hard for half an hour, trying to figure out the car is not moving. Nothing is happening. Then I called the automobile manufacturer, blasted him. Being a high court judge, he, patiently heard me out. And then after almost 15-20 minutes, he said, "Sir, can I say something?" So he said, "Sir, do you see the odometer in front of you?" I said, "Yes." "Is there a green? You will see it in green. That ready, you will find it in green. Do you see that?" I said, "Yes." "Now, sir, the car is on. You just have to push the accelerator and go ahead." So this is what the switchover is. And this is the change that all of you will have to learn. There's nothing much. Today, if I am asked as a lawyer or as a judge to go to the trial court, I'll find it very difficult. In my practice days, I was told sometimes that, "Sir, we have a brief for you, and we will pay you as much as possible, but please come to the trial court and argue this matter." So I would say, no, I'm very busy. The real fear was I couldn't practice in the trial court. So this is what it is. It's an art, practicing in the trial court, the art of cross-examination. Second appeal, I'm telling you, second appeal, the one who can do a second appeal can argue any matter. Because in the trial court, you learn the intricacies of each and every small thing, the smallest of details. You know all the provisions of CPC. You'll know all the provisions of the Evidence Act. So you are equipped with all this. Only thing is that switchover. which I'm very happy that the lawyers in Kolhapur are observing. They are watching the lawyers who are practicing in Bombay. I find many familiar faces here who sit in the court. Mr. Shah had sat in the court for a long time. His advocacy will be simply superb, I can tell you, because on the first day, on the ceremonial bench, the way Mr. Shah addressed, the way Mr. Louis Shah addressed, and the way Mr. Kapse addressed, it was absolutely phenomenal. So, Sangram we have heard on the day of the inaugural. It was a grand function, the way he speaks. Today, the way he articulated. There's nothing much to be said. I'm sure you have leaders. You don't need us. Let me tell you very frankly. You just don't need us. After 2 or 3 months, you will say, well, we are happy. We don't want to invite you. We'll invite our own. And that is what I would want you to come to. And in the next 10 years, I'd say, 10 years, of course, I won't be there. My brothers, Chapal Gaukar, Ashwin Bhobe will be leading. And they should tell me that, well, Kolhapur bar is one of the best bars of the country. That is what we look at. Thank you so much. God bless you all.
Thank you all the judges for your profound and enlightening address. Your words have truly set the tone for the session to follow. I now request Advocate Suraj Bhosle, Joint Secretary, Kolhapur District Bar Association, to deliver a vote of thanks.
Good morning, everyone. All the dignitaries on the dais and off the dais. It is my privilege to express vote of thanks on this occasion of the inaugural function. On behalf of Bombay High Court Kolhapur Bench Action Committee and Kolhapur District Bar Association, I sincerely thank our today's guest, Honorable Justice Sri M.S. Sonak sir, for gracing this event. I also express my gratitude to our guest of Honorable Justice Sri Makarand Karnik sir, Honorable Justice Sharmila Deshmukh ma'am, Honorable Justice Sri S.G. Chapalgaonkar sir, Honorable Justice A.D. Bhobe sir, Senior Counsel Sri Narendra Walawalkar sir, Principal District Judge Srimati Kavita Agarwal ma'am, Member of Bar Council of Maharashtra Sri Sangram Desai sir, President of Kolhapur District Bar Association V.R. Patil sir, and all the dignitaries on the dais, of the dais, for their valuable presence. I also thank all the seniors and juniors, lawyers present today for this workshop. I know we are all eager to hear out the keynote speakers of today's workshop. Hence, once again, I thank all the dignitaries for their valuable presence and gracing today's function. Thank you.
With that, we conclude the inaugural ceremony and look forward to an encouraging day of legal discourse and scholarly exchange. There will be a break for 5 minutes, thereafter which we'll start with the function that we have gathered here for. I kindly request everybody to be seated. I request the chief guest to occupy the seats on the dais. Now I request Advocate Dr. Santosh Shah sir to introduce our first chief guest speaker, Lordship Justice Shri M.S. Sonak sir.
Good morning and namaskar. At the outset, we must all express our sincere gratitude to Honorable Justice M.S. Karnik, not only for overseeing the establishment and commencement of the Circuit Bench of Bombay High Court at Kolhapur, but also for his continued and tireless efforts in ensuring its effective functioning and success. I remember from the very first day he came here, he has been calling and inviting many of us to his chambers and discussing with us as to how effective, how functioning this bench would be and how many junior lawyers from 6 districts would come and appear before them. Thank you, sir, for your continued support. This workshop has been primarily organized under his vision and encouragement. We also extend our heartfelt thanks to the other honorable judges of Bombay High Court who are here, who as a team have lent their invaluable support. Our first resource person for today, Honorable Justice A.S. Sonak, Judge of Bombay High Court. Justice Sonak is a proud son of the soil of Goa. Born in 1964, he completed his schooling at the prestigious Don Bosco High School, Panji, and pursued his BSc at Dempe College of Arts and Science. He obtained his LLB with first class from MS College of Law, Panji, Goa, and also holds a diploma in the Portuguese language. He began his legal practice at the Panji bench of Bombay High Court in October 1988 and soon earned a stellar reputation for his expertise in civil and constitutional law, labor and service law, environmental law, commercial and tax matters, company law, and public interest litigation. Over the course of his distinguished career, he served as additional standing counsel for the central government and as a special counsel for the government and various statutory corporations. Justice Sonak was elevated as additional judge of High Court of Judicature at Bombay on 21st June 2013. Currently, he is amongst the 5 senior most judges of Bombay High Court and also serves as something other than what his formal introduction is, as most of the honorable judges expressed. It said, sir, that a judge should be gentleman first and thereafter his knowledge of law would take him through. I think you have both in ample abundance in you. You are not only a gentleman, both the ways, as a gentleman as well as your knowledge of law, I'm sure will take this crowd to some other heights today. I would be remiss if I did not highlight a particular remarkable contribution of Honorable Justice Sonak. And this is a new development of law which we at even trial court lawyers should know, because we all make wills, and the wills that we know of are only the wills which are to take effect after a person. Now, in view of the Supreme Court judgment in Common Cause versus Union of India, now it is possible for people to make a living will, and Justice Sonak is the first person in Goa to have registered his living will. That's, I think, very exceptional and remarkable of him. He is widely known for his deep interest in mentoring young lawyers and inspiring the next generation of the legal community. I am confident that his words of wisdom today will go a long way in encouraging and motivating our young lawyers to take up practice at the Circuit Bench of Bombay High Court at Kolhapur. Thank you, sir, for sparing your valuable time, and thank you for being here. Thank you.
I now request Lordship Justice Shri M.S. Sonak, sir, to begin his lecture.
Walawalkar Sahib, I feel really honored to speak in your presence. Thank you very much. My colleagues on the bench, with their permission, I am deviating from the usual protocol. So my colleagues on the bench, dear Makarand, Sharmila, Santosh, and Ashwin, respected members of your Advocates Association, and my dear friends, in fact, fellow students, but fellow students would be a correct address. Friends, let me say that very, very few people can have the privilege and the fortune of realizing their dreams to come true during their own lifetime. And you are that proud generation where your dream, for which you have carried out a sangram, and so have many others before you carried out this valiant struggle to see your dream realized. And for this, you should, and we all should, eternally remain grateful. And we have to do everything within our means to see that this struggle has not been in vain. We should always remember the efforts that are put in for the last 45 years. There was a lot spoken about English and how English is not the soul of advocacy. It need not be in India and should not be in India. Language is only a vehicle of communication. Just as you may have some misgivings about expressing in English, I too have serious misgivings about expressing myself in Marathi. But in the context of which I was speaking, allow me, if I can remember, to quote a few lines from a great poet from Goa, Marathi poet Walawalkar. And he says, of course, in the context of our freedom fighters, and I would like to substitute it here in the context of your valiant struggle for seeing this day to come true. And Walawalkar says that Yadni Janni Deuna Nijashira Ghadile Manavitetse Mandira Parijayancha Dahana Bhumivar Nahi Chira Nahi Panati. So friends, I urge you today that be grateful to all your seniors who started this struggle and gave you this golden opportunity to see this golden day. We must never ever forget them, and not only not forget them, but not do anything that will disappoint them or that would make them feel wherever they are that their struggle has been in vain. Now we should also thank some people in our generation who have done their utmost to see that this circuit bench becomes a reality. And we cannot forget our present Chief Justice of India, Justice Gavai. We cannot forget the role played by my dear brother Makarand. We cannot forget the role played by your representatives who made an excellent presentation before all of us in Bombay. Whatever were the misgivings, they helped to clear those misgivings. Let us start with a good spirit. Let us not remember the people who opposed this project. Let us not remember the people who made fun of this project. Everybody has a right of expression. Let us honor their expression. The only way to make them realize that they were not right is by we giving in our best, by we trying to achieve our excellence. So the people who had some misgivings or the people who felt that they ought to criticize, I'm sure one day they will turn around and realize how wrong they were. It is your conduct and your vindication that should prove them wrong. Never try to argue with them. Never try to even contradict them. The best contradiction would be your success, making this golden opportunity into something much better than what gold ever would be. Now with this preamble, dear friends, let me confess that I somewhat feel in a position of a lawyer who has come unprepared to argue his brief in the court. So my natural reaction would have been to seek an adjournment on some ground, but there is a full bench sitting over here, and adjournment was not really an option. So I will do what is second best, and that is to try and express my thoughts before you. Friends, I must say that I have very fond memories of Kolhapur. As soon as I was appointed, I was a guardian judge along with Chief Justice More. I was also present and I spoke at the inauguration of this wonderful building. I am very, very happy that the Kolhapur circuit bench has become a reality. This is a milestone in the judicial administration of our state, not just of our region. Kolhapur has always been an important seat for administration of justice right from the times of Chhatrapati Shahu Maharaj. Now this bench is a step in restoration of that glory. This bench is a message, not only a message, but a message coupled with action that people of this region need not go far to seek justice. Justice has now come to your doorsteps. Justice or access to justice will now be near to you. But dear friends, always remember one thing, that with all this comes a lot of responsibility, and that responsibility is to be primarily shared by the judges and you, dear friends, the lawyers. Our excuses for not rendering justice should go. Second thing what I would like to emphasize is that please remember, and I urge you with all my humility, that these courts, these benches, these circuit benches are not meant only for judges and lawyers. Not meant for judges and lawyers at all. They are meant for the people who are seekers of justice. We are only facilitators. We are only here to see to it that they gain access to justice and they actually receive, however elusive that concept may be, they actually receive justice. So be clear always that this is not about increasing my practice, or this is not about judges writing beautiful judgments, but in the end missing that the main point was justice. This is all about problem solving. People have problems. See, there are only a very few people who come to the court just for the heck of it or for fun. They have a problem. They have a very serious problem. They do not know what to do with that problem. They have nowhere else to go. And it is in that desperate situation that they come to you and us seeking some solution for the problem which they are facing. So it should be our duty, our collective duty, that if within the four corners of law, we can do something to make his pain lesser, to solve his problem, then it is our duty to help each other to achieve that result. So always keep this in mind. Success in the profession, do not worry. Keep working hard, keep working honestly, keep working with integrity. Success is something that will follow. I am not too good in speaking Hindi, or I am not any authority on Hindi movies also. But if you recollect the end scene in The Three Idiots, they say, काबिल बनो, कामयाबी तो क्या झक मार के पीछे आ जाएगी. So be competent. Don't ever think about I wanting to race some other lawyer, or I wanting to establish a practice greater than what I have today. There will be a time when you will not even realize that you have gone very far, and precisely because you were not thinking about all this. Now with this preamble, allow me to refer to certain things which have been penned down very eloquently by Fali Nariman in his book Before Memory Fades. And this is because, as I confess to you, that I have not had the time to prepare too much for this presentation. Now, as a lawyer, there are a few points which he has written down, and I would just share them with you. The first thing he says is that let your opinions be honest and responsible. When a client comes to you, think over his matter. Decide whether it is worthwhile going to the court or not. Give him an honest opinion that this is what you feel are the chances of success, or this is what might happen if you go to the court of law. Now, there are always clients who will say that, I don't mind, let us take a chance, let us persuade the judge. Now, in such a situation, it is up to you to decide to file a case. There's nothing wrong in that. Because always remember one thing, that this might be your opinion that the client does not have a case, but the judge's opinion may always differ from yours. So there is nothing wrong in trying out. I don't mean taking a chance as you take a chance in a casino or in a gambling hall, but take an honest chance. But as between you and your client, please be fair, please be honest. Don't give him any false hopes. It puts an unnecessary pressure on you, as well as it gives some false hopes to the client. The second is, as my sister Sharmila has also pointed out, that the essence of good lawyering is acquainting oneself with the relevant law, including the case law on the subject at hand. The facts the client is going to explain to you, all right, broadly at least. Familiarize yourself with what is the law. Let me share that there used to be many instances when a client would come to the chamber, would explain his problem, and I would be completely blank because this was a subject which I had never ever dealt with. So on the first meeting or in the first conference, this is excusable. No harm. Law is such a wide subject that it is practically impossible for every lawyer to be acquainted with all its facets or to be acquainted with all the subjects. But after that first meeting, and you give him an appointment after maybe 2-3 days or after a week, depending on what your docket is, for that second meeting, I think you have to be fully prepared. You have to know in which law his problem might find a solution. You have to study that law. You have to see whether within the four corners of law you can give him some redress. So that second conference is most important from the perspective of a lawyer. Third thing is, whenever any client comes with a problem, first port of call should be common sense. Let us admit, dear friends, that law to a great extent is common sense, which is unfortunately made very complicated by lawyers and judges to justify our existence. But let us not forget common sense. By common sense, what do you feel would be the solution? What do you feel should be the law? And you are bound to, with your industry, find some legal precedents, find some provision in the law which will align with what you regard as common sense. So therefore, this attitude of immediately jumping to the case law, try to resist it. I have nothing but admiration for your generation. You are absolutely equipped with digital progress, with technology, with legal software. But friends, please realize one thing, that all this artificial intelligence is fine. We have to welcome it. There is no saying that we don't have to welcome it. And especially, we have no right to say it. We are a chip of the old block. But this artificial intelligence should not be at the cost of dystrophy or disuse of our own original thoughts. You should not, what they say is that if you don't use your right arm for a long time, then that arm will become useless. It will do no work. It will virtually be paralyzed. Similarly, if you don't exercise your brain and give up the habit of original thinking, and every time there is a problem, you only think of a keyword, punch it in and get some case law and want to argue your case based upon that, that is not a very healthy sign. So always develop the attitude of original thinking. In fact, it was Nariman. He says that the most important part of arguing any brief is just sitting and thinking on the matter. Spend some time thinking. What is it? What is this case? What is it that my opposite side is going to argue? How do I counter it? Where is the judge going to stop me? Always have this kind of an attitude. It takes some time, but once it becomes a habit in you, I think that will be an invaluable habit. Now, whenever you argue a case in a court of law, be clear, precise, and not confused. Friends, the best lawyer is the one who can weave and tell a story to a judge. See, both of us are here to help the party before us to achieve justice. Now, it is your duty, in fact, it is our collective duty to help each other to reach to that position. So therefore, if you explain to the judge desperately requires help from you. So a synopsis, especially in the High Court, a short synopsis, a clear synopsis, the right case law, not a case law diarrhea, not too many cases or too many high courts, but a case which is precisely supporting your point of view is of great help, and that helps a judge in deciding the matter in a proper way. So always try to get into this habit. With deepest respect to the original side pleadings in Bombay, they possibly charged by the page. They possibly charged by the page. So therefore, every petition is usually 150 pages. And out of which 10 pages would have been more than sufficient. I mean, we would have been happy if for those 10 pages itself they would have charged 10 times the fees. But we don't know. So, develop a habit of being clear, precise, helpful to the judge. Helpful in this sense that you have to explain. Always, I have this problem that whenever a lawyer starts an argument, if he does not tell me in the first 1 or 2 minutes, what is this case about, I get extremely impatient. Now that is because of my age, because of my bad habit, and because of irritability that has inevitably and unfortunately developed after so many years of being on the bench. There, please don't hold me as an example, please only hold me as a warning. Don't learn these things from me. But you as lawyers have to accommodate all kinds of judges. That is not your choice. Some judges will be kind, some judges will be extremely brilliant, some judges may not be as much brilliant. But then, as a lawyer, you have to always realize that judges are also human beings. We call the court a temple. But that doesn't mean that those who preside in the court are gods or they are anywhere close to divinity. We are ultimately human beings. We also have our faults. We also have, unfortunately, our egos. And you people pamper our egos by constantly calling us your lordship and I beg to appear and forgive me and so on. That is an unfortunate legacy of a colonial age. But we always try to tell ourselves that this is not true. But you should also realize, and you should also please make some allowances for the fact that we are also overstressed, we are also human beings, we also have our own faults. You have to accommodate for all those. And similarly, as judges, we have to accommodate you. Always remembering that this is not about you and us, it is about the matter before us. And when we talk of the matter, it is not just the brief or the pages, but it is that poor person who is crying for justice. The face of the person who has approached us with so much of hopes and so much of aspirations. Friends, I am sure that there may have been so many cases which deserved to be carried to the Bombay High Court. But because of the distance, because of the financial difficulties, because of the stress of having to come to Bombay, engage an advocate, pay the fees, stay there, so many litigants must have said, I'm sorry, I cannot afford to go any further, so I will tolerate whatever has been done over here. Today at least, with the circuit bench, this situation has been remedied to some extent. Make the best of it, dear friends. There is another thing which is quite interesting, these are some small things, like many a times the lawyers say before me, your lordships will please bear with me, and so on. So, Justice A.N. Ray from the Supreme Court, Mr. Nariman has quoted, whenever any lawyer said that, he would say that, what do you think I have been doing for the last 10 minutes? So, these are some small things, but one thing which, or two or three things more. One of the things is better to understate your case than to overstate it. Never ever start your argument with, my lords, I have a 100% case, or that this is an open and shut case. The moment you say that, it is wrong on our part, wrong on part of some of our colleagues. But then we also go a defensive. Oh, you think it's a 100% case? I will find out some fault. So always pitch your case at a proper level that it deserves. Even if you are confident that it is a 100% case, don't state that it is a 100% case. Then never ever say to a judge that I have never heard such a thing, or that there's a nice story of a young lawyer who practiced, there's a story in England. He argued a case which he thought he argued it extremely brilliantly, but the judge finally dismissed the case. So when the order was pronounced, this young lawyer stood up and said, my lord, I am shocked at your decision. And the judge was also quite taken aback, and he said that, Mr. So-and-so, I am issuing you a contempt notice. Please answer at 2:30 why I should not commit you for contempt. That lawyer was completely devastated. He went back to the bar room. The bar room is the solace where we have the benefit of very, very senior lawyers like Mr. Walawalkar, who will always pat you on the back and soothe you and say that, don't worry, I will handle the matter. So some such senior lawyer appeared on behalf of this young lawyer at the 2:30 session, and he told the judge, he said, my lord, he has just started his practice. He's there for hardly a month in practice. He's not like me, where I have put in about 30 years of practice. Once he reaches my level, I assure you, your lordships, that he will not be shocked with anything that your lordships do. The contempt had to be dismissed because the judge didn't want to get into anything further. But never exaggerate about your case in a court of law. Avoid a rhetoric. Avoid trying to give an impression that you are too smart, that you are trying to pull some fast one on a judge. See, these things don't help. Never make an absurd argument which you know will not really stick. Many a times you are angry. Leave that anger outside the courtroom. Here you are not, it is not, again as I say, it is not between you and the judge. This is not some kind of a match between you and the judge. You are here only to put the cause of your client. So always do that. There is one more situation. Other thing is, never ever quarrel with your opponents in the court, the lawyers. You may argue, you may oppose every contention. But please remember that just as for judges, our colleagues ultimately become our family. So also with all of you, it is your colleagues that become a part of a large family in which day in and day out you come, you practice, you share a collegiality. So therefore, never have any rancor, never have any grudge, never have any opposition amongst yourselves. Argue on points of law. Obviously, you are trained to and you are expected to. They say that the origin of lawyering was that whenever there was any problem between A and B would actually fight a duel with swords. And then whoever wins, the presumption was that he was always right. So might was always right. Then there came a law reform. And the law reform was that A and B would not actually fight, but they would engage gladiators who were professional fighters to fight. Gradually, then those gladiators shed their arms and began to use their tongues. And that is where we are as lawyers. But then always remember that our role is to present our client's cause boldly, courageously, fairly. Explain the judge what the problem is. And based on that, accept the decision. I am not here to say that you have to accept any nonsense from a judge, even conduct-wise. You are as much officers of the court as much as the judges are. But never intentionally be rude, insult, ridicule, either way. Secondly, if you feel that a decision is wrong, obviously with all force at your command, appeal the decision. File a review. Take out all legal means to see that that decision is set aside. But unless you have concrete proof, and unless you have some verifiable facts with you, don't indulge into making personal allegations against a judge. Very few judges can really hold press conferences and answer for themselves. None of us can really do that. We decide according to our conscience. We are conscious that we can be wrong. We can be fallible. We several times we are fallible. So saying that our judgment is wrong, no problem at all. But to say that no, because of extraneous considerations, this judgment has been delivered, that hurts. That hurts because we have no way of responding to your allegation. And by this, what we do is that we weaken the institution itself. This is again not about you and us. It is about the institution. So if we start making allegations against each other, we are doing incalculable harm to the profession itself. Next thing is, have you all heard about that Irish clock? Irish clock is that huge clock which has a nice pendulum and all that. Now those Irish clocks are supposed to be extremely durable, especially the clocks made in Ireland. But one of the ways of noticing that the Irish clock has gone astray or is now not workable is sometimes when there is a problem in that Irish clock, whenever it is 12 o'clock, instead of giving 12 chimes, it gives what is known as the 13th chime. Now this is what happens sometimes in law. A lawyer, if he starts making incorrect statements before a court of law and loses the confidence of a judge, then as I told you, see, we are also human beings, then we tend to mentally blackball a lawyer. We feel that this lawyer is not reliable. I cannot take him on his face value. And that is what is the phenomenon of the 13th chime. Once the clock gives the 13th chime, you know that there is a problem. And the problem is so severe that even though the first 12 chimes were correct, you begin to doubt whether they were correct or not. So therefore, once a lawyer creates an impression that he is not reliable, or that impression may be right or wrong, but try and see that such an impression is not created. Once that impression is created, it becomes extremely difficult for the lawyer. But forget the lawyer. It becomes difficult for the clients he represents. There may be a situation where a client of yours genuinely requires an urgent ex parte relief. But if as a judge, I feel that you are not reliable, I am not confident that you are stating all the correct facts before me, I might refuse you that injunction. And that might be a very gross error for which your client will suffer for no fault of his. So always create an impression that on law, you have full liberty to argue whatever you want, as long as it is not absurd or beyond the bounds of reasonability. But on facts, gain the confidence of a court, saying that this person will tell me all the facts correctly. This person is not going to put me in trouble by making me deliver a wrong judgment. So gain the confidence of the court and gradually things will follow. Learn also to lose with dignity. Friends, winning or losing is really not in your hands. What is in your hands is giving in your best. Always strive to give in your best. Many a times you lose a case not because you are wrong. Judges also can be wrong. These are matters of views. Many a times we take a view and the Supreme Court reverses us or overrules us. Not necessarily that the Supreme Court view is right and we are wrong, but hierarchically their view binds us, so we will follow that view. There are so many instances where the Supreme Court reviews its own decision, or a wider bench of the Supreme Court itself says that the bench of a lesser strength was not right. So please realize that ours is a learned profession. Ours is a profession that deals with thoughts, that deals with views, that deals with arguments, where there's nothing like absolute right or absolute wrong. So treat it accordingly. There is some issue which Mr. Nariman has, which we really need not discuss, about lawyers giving interviews to the media. But that's for you to take a call. What happens is that if you start giving interviews to the media, presenting only your case, then very often the trial becomes a media trial to which there is no much response that can be given. So friends, your skill is not flamboyance or verbosity. And in particular, let me tell you one thing, that never ever feel diffident because you perceive that your English presentation is not good. I am very, very sure that the judges of our High Court are not going to judge you by the English that you speak. They are going to judge you by the content of your argument. And let me share, when I came here as a guardian judge, we used to have workshops for our judicial officers. And let me be very candid, and I have said this so many times, that in Goa we used to pride about our bar being one of the best. It is really a nice bar. We used to also equally pride saying that our judges write better language because they are equipped in English. But when I came here, particularly in Kolhapur and also in Satara, for those workshops, our judicial officers, they had only a problem of expressing themselves in English, but their fundamentals were at least 10 times stronger than the fundamentals of our judicial officers way back in Goa. And I'm sure that is the situation today. So don't have any kind of complex. Their fundamentals were so good, they would start in English and they would say, ki mi Marathit bolu ka? And in Marathi, in simple words, simple language, the way they would express complex terms was phenomenal and fantastic. So please never ever have this in your mind. Ultimately, please remember one thing, that whenever anybody pointed out a mistake in my English, I would always say that I am a true patriot and I love to murder the English language. It's not our language, it's a beautiful language. I respect that language also. All languages are beautiful, but languages are only vehicles to communication. The point is how you put across your story or your client's story to the judge. That is what is important. The content is important. In fact, one of the criticisms, there's a very beautiful article written in 1944, and they said that there are two problems with English pleadings. Two major problems which we have to address. And the author starts by saying that the first problem is style and second problem is content, which means that it includes everything. So there are that way. So don't worry about such factors at all. Secondly, I am sure that the judges who are right now here at Kolhapur and the judges who will also follow them, we are genuinely interested, and it gives us a lot of pleasure when a junior comes and argues before us. at least in my court, and I'm sure in Makarand's court, Sharmila's court, Santosh's court or Ashwin's court, our attitude would be that the junior should start the arguments. Tell us what the case is about. And if we can give him a favorable order, we would be most delighted. If we can't give him a favorable order, then the least we will do is that we will give him an adjournment and wait for his senior. Because we do realize that the client should not feel that he lost the case because the junior was not able to put it up across. That would lead to a lot of embarrassment. That would lead to an embarrassment to the junior, to the senior. So we will wait. I am a bit harsh. I'm very harsh in the court on adjournments. But that is because I assure the lawyers. And then it irritates me when the lawyer comes and says that I have no brief, I have no instructions to argue. I won't argue. I always tell him that now I'm going to dismiss it for default. Next time you prepare and come for restoration. I assure you I will restore it. But today let me dismiss it. Not that I have the heart to do it ultimately, but I say this. So therefore, dear friends, please come to the High Court. Please come to the bench, which you have now got after such a hard-won battle. Please come. Just sitting over there is education. You realize what the judges expect. You realize how the lawyers put up their cases, how they are appreciated. That's a learning experience. That is a true classroom. And always come with your brief, always come prepared. If there is a chance, please start the argument. And I'm sure you will be accommodated. And this gradually builds up. Come with the full confidence. See, friends, we realize that there are a lot of problems. But legal profession is one which I sincerely believe that more the adversities, more the chances that you will succeed in this profession. What you have all heard about influenza, but one of the biggest problems for lawyers, please believe me, is something known as affluenza. If you are too affluent and you don't have any incentive to work hard, or if you have no incentive to struggle, then there are chances of you not doing as well as you ought to be doing. So don't think about, I have these problems. Everybody has problems. Yeah. I'm not undermining those problems. But have an attitude that I have become a lawyer. I have now got a chance to appear before the High Court. I have now a chance to do this service. Make the most of it. All right? And have full faith in yourselves. Have full confidence in yourselves. Even if there is some incident in the court where the judge fires you, please accept it. We have all gone through those phases. In fact, a lot of people ask me why I became a judge. I said, I could not beat them, therefore I joined them. That is perhaps one of the reasons why Ashwin came to this profession. Huh? You are 9 months not giving him any order. But it's always that way. Always remember that we also have our own days, we also have our own idiosyncrasies, we also have our own moods. This is unfortunate, but please realize that we are not some divinity, we are not some gods, though we may sit in a temple of justice. We also have our own issues. Please be understanding of us. And similarly, it is our duty to be understanding of you. It's an ideal situation, but there are no idealities anywhere in the world. Let us look at the practicalities and let us move on. I have taken a lot of time, but let me just give you a brief about what happens in the High Court. Makarand, it is okay? I can? Yes. See, broadly speaking, you deal with a lot of, about the criminal matters, it's not my forte, so I won't talk too much. But you deal with a lot of civil suits. Once the suit is decreed, depending on the valuation, you have a right to file a first appeal in the High Court, Order 41 and corresponding section in the CPC. Now that first appeal, though there is some case law which says, in the High Court we usually have a procedure where a matter has to be first admitted and then it is set down for final hearing. Now the purpose of admission is broadly to screen a matter, whether this really requires to go to the final hearing stage or it is so frivolous that we should dismiss it at this stage itself. If it is a covered matter, then obviously we will not want to entertain it. But when it comes to a first appeal, please remember that though there is some case law which says that it is not an appeal as a matter of right, 99% of the times the courts would admit a first appeal, simply because that is an opportunity for you to argue both on law as well as facts. Everything is really open before the first appellate court when you appeal against a decree. So that is something which I would urge you as junior lawyers, that if you are in a suit and the suit has been decreed against you and you have to appeal against it, please don't engage any counsel. You argue it, you draft it, say how the judge was wrong, right from point 1 to point. Makarand was very nicely telling me this morning itself that, and we all did that. Appeal memo is the judge erred in doing this and everything, practically erred in everything. All right, no problem. And argue the first appeal, 99% chances that the appeal would be admitted. Now when it comes to interim relief, that's where you'll have to be prepared. The judge may not easily grant you an interim relief, so you'll have to basically make out a case that the order has some problems, I need to be protected pending my appeal. Now similarly, so those are quite a few of the cases which you should take up and you should argue. Then we come to appeal against orders, basically order 43. They list out what are the orders against which you can maintain appeal against orders. Now they are appeals against interlocutory orders pending the suit. Now there is a leading judgment in the case of Wander. You will find it out, Wander versus Antox. There the Supreme Court has explained that when there is an appeal against an interlocutory order where the trial judge has basically exercised discretion, then there is a particular way in which you should argue the matter. Because the appellate court is not going to substitute its own view for the view of the trial court. You have to really make out a case that the trial judge has erred on a principle of law, or that the trial judge has exercised discretion capriciously, whimsically, which no legally trained person would have really exercised. So you have to make out a case of a much higher degree. And the principle is this, that ultimately this is an interlocutory order. Even if we don't interfere at this stage, ultimately if the suit is decided against you and you have to appeal the decree, then the provisions of CPC say that such interlocutory orders can also be thrown in challenge. So there you have to be careful, especially against injunction orders. Now an injunction is refused. You call it as Exhibit 5. No? Exhibit 5. Now that is rejected or that is granted. When you are appealing against that, be prepared. Read what are the parameters that are expected, accordingly formulate your grounds, and in the first 2 or 3 minutes, try to tell the judge that this is the greatest error of principle and that is why I need an admission. So that is insofar as appeal from orders are concerned. Civil revision applications are even more restricted, and now with the proviso, they are still more restricted, but they are basically to correct the errors of jurisdiction. You have to make out a case not simply on reappreciation of facts, but to make out a case that the judge has exercised jurisdiction which was never vested in that judge, or has exercised jurisdiction or has exercised powers in excess of jurisdiction. So again, in fact, my favorite book was a book on CPC by C.K. Takwani. I would read it during my college days, and I still have a copy. In fact, I carried one also with me, but I forgot to bring it here. But it's a very nice book. C.K. Takwani is nothing but Justice C.K. Thakkar, who was our Chief Justice and then who went to the Supreme Court. It's a beautiful book, written in the most simple language, explaining CPC chapter-wise. See, if you start going by sections and articles, he has explained res judicata, there is a chapter. On stay of suits, there is a chapter. On bringing legal representatives, there is a chapter. So it's done very nicely. The structure of the book is very nice. Leading case law has been discussed over there. It's a good book for principals. In fact, it is a book meant for law students. But friends, please remember that in this profession, we continue to be students. Each day as you keep studying, all that happens is that you realize what is the magnitude of your ignorance. The moment you start feeling that I know everything, it means that you have stopped learning. So therefore, use some book of this kind, but not only this kind. This is only to get the fundamentals cleared up. After that, you have to refer to some standard commentaries. You have to refer to your case law. And always remember about case law. First, make up your mind that according to me, this is the solution. After making up your mind, try to go to the case law. The case law may either affirm your opinion, which is a very nice thing, that whatever was my opinion, even great Supreme Court judges also have the same opinion. So you can always be proud and say that great minds think alike. But always never forget, there is another phrase in English language which says that fools seldom differ. So that's a contradiction. But do that way. So this is insofar as revisions, appeal from orders, or first appeals. The other most widely used jurisdiction in the High Court is Articles 226 and 227. All right. Now we'll take up 227 a little bit. 227 is not essentially a writ jurisdiction, though it is clubbed or called as writ jurisdiction. Now the Supreme Court has explained that under 227 it is not as if we issue writs, but we only exercise supervisory jurisdiction over courts and tribunals or quasi-judicial authorities. And the purpose of this exercise is to see that they are within the bounds of their jurisdiction. Alright, so say suppose now some authority does not have any jurisdiction. For example, a classic case would be that if the civil court proceeds to order the eviction of a protected tenant, when in fact your tenancy laws say that civil courts have no jurisdiction. If a tenant has to be evicted, then there is a procedure provided under that act. Now, it means that the civil court is exercising jurisdiction which it does not have. So, perhaps an order could be questioned under 227, saying that you don't have jurisdiction. Now, please remember that there is a difference between an error of jurisdiction and a simple error of law or of fact. 227 jurisdiction ideally is to be exercised when there is an error of jurisdiction. Within jurisdiction, if the judge is going to make a mistake, then 227 is not your correct remedy. You might have some other remedy of an appeal or appeal from order or whatever. You have to find that out. But that's not the purpose of 227. All right? And 227 will lie not only... so therefore, in the CPC, many a times there are certain orders which are neither amenable to revision, nor to appeal, nor to an appeal from order. In such situations, you invoke the 227 jurisdiction. That's one. Second thing is there was a controversy on whether under 227 you are supposed to make the authority a party, because you are asking for some order against them. Now the Supreme Court says that it's not necessary. You need not make the authority as a party. But that is insofar as 227 jurisdiction is concerned. The widest is 226. And I was just discussing with the senior advocate, Mr. Walawalkar. 226 jurisdiction is so wide that the width itself should be a caution to all of us to exercise this power with greatest of restraint. It is like giving a Brahmastra in somebody's hands. And the Brahmastra is given not to destroy, but to use restraint. To use it only if it is absolutely necessary. If there is no alternate remedy, only then to use a 226 jurisdiction. 226 and 227 also form a part of the basic structure of our constitution. Friends, please appreciate that ours is a unique country where several countries have provisions where if an ordinary law conflicts with the constitution, particularly with part 3, or if a state does not have legislative competence, or if the union does not have legislative competence, then the court can strike down such a legislation. But ours is a unique country, and thanks to the decision in Keshavananda Bharati, where even a constitutional amendment can be questioned on the ground that it violates the basic structure of our constitution. So for example, tomorrow, if the parliament decides we have a brute majority, we are going to delete Article 21, we are going to delete Article 14, or if the term of office of an elected government is 5 years, by a simple amendment to the Representation of People's Act or to the Constitution, we will make that 5 years into 25 years. Now that would have been theoretically possible. But now Keshavananda Bharati says that that would be playing foul with the basic structure of the Constitution. And if you do that, then the courts can interfere and even strike down such a constitutional amendment. So in that light itself, they have said that the jurisdiction under Articles 226 and 227, that is the right of judicial review. See, please don't realize or please don't consider that this is a power given to the court. This is a right given to a citizen to access independent courts. Independent judiciary, that is not some privilege given to judges. It's true that we have to be independent, that is our duty, but that is a right given to the people to have their cases resolved by an independent judiciary. So it is in public interest to have an independent judiciary, not in the judge's interest to have an independent judiciary. So that is all a part of the basic structure of our constitution, 226 and 227. Now 226, there are certain principles. One thing is 226 is utilized to question legislations. If any law is unconstitutional, then you file a petition under Article 226, question the constitutional validity of that legislation. About Article 32 we will not discuss now, that's the power to the Supreme Court, but 226. Now 226 also is available to challenge a host full of administrative actions of the state. It can be issued for other purposes also. It can be basically issued for violation of fundamental rights and also for other purposes. So 226 is an extremely important area which I think you will have to study, master. Practically everything is open under 226. And because the Constitution does not impose any restrictions on the courts to exercise such large power, we have, through case law, imposed certain self-imposed restrictions. Now, one of them is that this is a summary remedy. So normally in this remedy, we do not take evidence. We do not bring witnesses. It's not that we are not empowered to. But normal procedure is that this is a summary remedy. It's a quick remedy. So therefore, if there are disputed questions of fact, we will say to a party, you please file a civil suit because this will require evidence. Similarly, if you approach the court after where the doctrine of laches is applicable. See, there is a difference between delay and laches. Delay is mere physical running of time. But laches is that if on account of the delay, some parallel rights have accrued in the opposite party, and then it is inequitable at this stage now to question it. Like for example, a student is admitted to the first MBBS course, and then after 5 years, somebody comes up and says that now please cancel this admission because it was wrong for ABC reasons. The court will say that why did you sleep on your rights for so long? He has now virtually completed his education. I am not going to interfere at this stage. Similarly, if you have an alternate remedy, statutory remedy, if you have a right of an appeal or if you have a right of a revision under some statute, then they'll say please go there. It is only if you have no other remedy, no other equally efficacious remedy, that we will entertain a writ petition. Fourth is your conduct. If the court finds that your conduct is not proper or that you are trying to enforce something which is completely inequitable, you might be right in law, but there is a difference between law and equity. If they find that your conduct is inequitable or the relief that you seek is inequitable, the court will decline because these are equitable and discretionary reliefs. So these are some of the principles. Or if you have come to the court with unclean hands, see, that is a rule which is followed very strictly. If you have suppressed a material fact, if you have tried to pull a fast one on a court, the court will say that you might have a 100% case on merits, but because you tried to do this, we are not going to entertain the 226 jurisdiction for you. You see if you have any other remedy, but this court is not for you. All right? So, study all these aspects. Familiarize yourself with all these aspects. They are not at all rocket science, as Santosh said. It is a question of practice. It is a question of familiarizing yourself. There is absolutely nothing difficult. It is common sense, but which we have made complicated to justify our existence. So therefore, and natural justice. See, almost about 25 to 30% of the cases that we deal in the High Court deal with one or the other facet of natural justice. Familiarize yourself with natural justice. See how this concept started. First, there were only two things, that no person can be a judge in his own cause, or you hear the other side before you prejudice them. See how our law develops, and the credit for that development goes to the lawyers. Now, first thing was that hear the other side. So the lawyers argued that if your show cause notice is vague, if it does not give me what is the fault which I have committed, then this is not hear the other side. So a vague show cause notice is itself failure of natural justice. Or if the authority is relying on certain documents, but you have not been given a copy of those documents, you have not been allowed to meet with that case. So the lawyers argued, saying that, sorry sir, this is not natural justice because you have relied on some material which is adverse to me without giving me an opportunity to comment on that material. So that is how the process develops, and the credit for that goes to the lawyers and to the lawyers who think originally. Ultimately, friends, there is no difference between you and us. Whatever input that you give us, that is our output. So they say that Marathit I feel diffident, पण असं म्हणतात ना की नदी आपल्या मुळाच्या पात काहीतरी आहे ना, that a river can never rise above its own source. Now you are the source for the judges. So as judges, we can never rise above your preparation, above your competence. So whatever you feed us, on that will depend the quality of our decision making. So the responsibility is really great on you. Always develop new arguments, always develop original arguments. That is what I would urge you. One of the things that you should never do in a court of law is to go on too long, just as what I am doing now. So if Makarand permits me, should I conclude here? But before I conclude, I would genuinely and very, very genuinely wish you all the best and tell you that don't focus on your problems. If you decide that you are going to focus on the problems, then you will go on finding several problems as to why you are not making it or why you are not succeeding. Focus on your strong points. First strong point is that yes, my parents could afford to let me study and become a lawyer. Waiting time is tough. If you read most of the autobiographies or biographies, you will realize how much of troubles everybody has taken to succeed in this profession. So don't let that deter you. All right? Don't let that deter you. They say that suppose you are digging for gold in a field or you are digging for some diamonds in a field, then your whole focus will be on finding out the diamonds in that field. You will be removing tons of rubbish. But your focus would be that I will get 1 or 2 diamonds. So always focus on that. Never be in competition with your colleagues. Be in competition with yourself. And never ever feel that I will not make it. The only question should be within how much time I will make it. And think of your clients. The success in the profession will follow. All right. See, as I said, that a judge is nobody except maybe a lawyer who is benched. There's no difference, frankly speaking. All right. Many a times we become judges for several reasons. I quite regret why lawyers who are doing so well refuse judgeship. Don't refuse. If you are offered a judgeship by your Chief Justice, which I am sure will eventually be offered, don't compare yourself by saying that, see, in practice, this is what I am earning and my income is going to be reduced by 10 times. Of course, if there are some special reasons, there are responsibilities, that's a different issue. But otherwise, it's a public duty that you should gladly accept. Accept it for the sake of the institution that has given us so much, for the sake of our country that means so much to us. Never say no if you are offered a judgeship, and do good practice so that you can ensure that justice is reached to those who deserve it the most. Okay? Thank you very much. And please excuse my lack of coherence, but I was extremely pleased and honored that Makarand invited me over here, and I will be extremely happy to see some of you adorn our Bombay High Court bench in near future. Thank you very much.
Thank you, Lordship, Justice Shri Sonak sir, for your kind words of wisdom, which will help all the advocates present here today. I now request Advocate Dr. Santosh Shah sir to introduce our next guest speaker.
Hello everyone again. As Honorable Justice Sonak said, good bar makes good bench. And people like Advocate Narendra Walawalkar, Senior Counsel, Bombay High Court, who in fact are the ones who, being members of our profession and bar, who I'm sure all the honorable judges here would agree have made a good bench. Advocate Walawalkar was born in a family of lawyers, but he has created his own mark with his discipline and dedication. Though his grandfather and father and uncle were all lawyers, he had no fortune to have their guidance at the time of joining the bar. In 1975, as his grandfather was no more by then and his father was in Yerauda jail as a détenu for about 16 months. He thus had hard times to see to his family in the absence of his father and to set up his own practice. He has taught law subjects in colleges like mercantile law for some period too. And today I'm sure his teaching skills would be seen by all of us. Mr. Walawalkar has observed very high standards of practice in terms of integrity, steadfastness, and principles. He has represented many big organizations in Bombay like MCGM, Bombay Municipal Corporation, Sangli, Miraj and Kupwad Municipal Corporation, Pimpri Chinchwad Municipal Corporation, Navi Mumbai Municipal Corporation in large number of matters, and many of them have always been hotly contested. On a personal side, as Justice Karnik said, it is not whether you win a case or lose a case which is important, it is how you argue which is important. My father, and I take the liberty of mentioning this, he saw Mr. Walawalkar arguing against him in a matter, and he was so very impressed by his arguments that though my father was against him, his client was against my father's client. In the next matter, he approached Mr. Walawalkar that you should take up our brief, and he argued a very complicated, huge matter from Kolhapur. I will not take the names of the parties in the matter. So that is his greatness. So let us all welcome Senior Advocate Walawalkar.
I kindly request Walawalkar sir to begin with his speech.
चालू आहे ना? नमस्कार. सन्माननीय सोनक साहेब, कर्णिक साहेब, देशमुख मॅडम आणि भोबे साहेब, या प्राचीन करवीर नगरीमध्ये ज्यांनी आपल्या कर्तृत्वाने या नगरीला महत्त्व प्राप्त करून दिलं, त्या राजाराम महाराज, महाराणी ताराबाई आणि राजर्षी शाहू महाराज यांना नम्र वंदन करतो आणि माझ्या या लेक्चरला सुरुवात करतो. मला वाटलेलं की हे बरंच सोपं होईल माझं लेक्चर. आता प्रॉब्लेम काय झाला आहे तो प्रामाणिकपणे सांगतो. आधीच्या सगळ्यांनी बरेचसे मुद्दे कव्हर केले, कळत नकळत पण आवश्यक असलेले मुद्दे सगळे कव्हर केले. आत्ता मी सोनक साहेबांना तेच म्हटलं की साहेब, आता मी काय बोलायचं शिल्लक आहे ते मला सुचत नाही आहे, पण मी आधीपासून तयारी केलेली हे कळावं म्हणून मी लिहिलेलं वाचून दाखवीन. पण काही मुद्दे मला माझे स्वतःचे मांडायचे आहेत, जे साहेबांनी, ह्या सगळ्या जज साहेबांनी सांगितलेले त्यांच्या बाजूचे मुद्दे आहेत. मला आता आपल्याला वकील म्हणून सांगायचे जे मुद्दे आहेत की ज्याच्यासाठी हे आपण लेक्चर अरेंज केलं, ते मी सांगणार आहे. सर्वप्रथम बार काउन्सिलने आणि कोल्हापूर बारने मला इथे बोलवलं, ही मी माझ्या इतके वर्षांच्या प्रामाणिकपणे केलेल्या वकिलीच्या व्यवसायाला दिलेली पावती समजतो आणि तुमचं सगळ्यांचे आभार मानतो. कर्णिक साहेबांनी सांगितलं आणि सोनक साहेबांनी ते रिपीट केलं की आपण जिंकलो की हरलो हे महत्त्वाचं नाही आहे, काय आणि कशा प्रकारे प्रामाणिकपणे आर्ग्यू केलं हे शेवटी महत्त्वाचं ठरतं. आणि ते मी पाळत आलो आणि म्हणून मी माझे काही अनुभव तुम्हाला सांगणार आहे. सर्वप्रथम मला असं वाटतं की सोनक साहेबांनी जे सांगितलं की हे टेम्पल ऑफ जस्टिस आहे, पण आम्ही काही गॉड्स किंवा गॉडेसेस नाही. साहेब, मी सन्मानपूर्वक आपल्याशी थोडंसं माझं डिझॅग्रीमेंट व्यक्त करतो की हे सगळे ज्युनियर्स आहेत आणि त्यांना हे महत्त्व पटलं पाहिजे की आपण ज्या टेम्पल ऑफ जस्टिसमध्ये येतो आहे, ज्याला आपण टेम्पल ऑफ जस्टिस मानतो आहे, तिथे हे न्यायमूर्ती हे देवतेच्या स्वरूपातच आहेत. त्यांच्यापुढे आपण नम्रभावनेनेच उभं राहिलं पाहिजे. आत्ता मला खरं टेन्शन आहे की मी उभा आहे आणि मी त्यांना रिक्वेस्ट केलेली तुम्ही सगळे वर बसा, मला टेन्शन येणार बोलताना, पण ते म्हणाले ठीक आहे आम्ही खाली बसतो. हे आपण न्यायमूर्तींना या न्यायालयाचं जे मंदिर आहे, न्याय मंदिर, तिथले देवदेवताच समजलं पाहिजे. परस्पर सन्मान हा या व्यवसायातला एक महत्त्वाचा घटक आहे. आता हे लिहिलेल्या भाषणाच्या बाहेरचं आहे, सांगतोय, जाणवलं ते. तुम्ही विचार करा, सुप्रीम कोर्ट जेव्हा हायकोर्टाला एखादी डायरेक्शन देतं तेव्हा ते असं नाही म्हणत वी डायरेक्ट हायकोर्ट टू डिसाईड अँड डिस्पोज ऑफ दिस विदिन 6 months. ते म्हणतात वी रिक्वेस्ट द हायकोर्ट. हायकोर्ट जेव्हा डिस्ट्रिक्ट कोर्टाला किंवा सिव्हिल जजला सांगतं की डायरेक्शन देतं की हा दावा 6 महिन्यात डिसाईड करा, तेव्हा हायकोर्ट असं नाही म्हणत वी डायरेक्ट. हायकोर्ट म्हणतं वी एक्सपेक्ट दी लोअर कोर्ट टू डिसाईड दिस विदिन 6 months ॲज एक्सपिडिशियसली ॲज पॉसिबल अँड विदिन 6 months 1 year जे काय असेल ते. हा सन्मान जर न्यायव्यवस्थेत न्यायमूर्ती देतात, आपलं परमकर्तव्य आहे की आपण बोलताना वागताना सन्मानपूर्वकच न्यायमूर्तींशी बोललं पाहिजे. मी सगळ्या प्रकारचे अनुभव घेतलेत. मी कोर्टामध्ये न्यायमूर्तींशी उर्मटपणे बोलणारे वकील बघितलेत. त्याने काय साध्य होत नाही. सन्मानपूर्वक आपली बाजू प्रामाणिकपणे मांडणं ह्याचा जास्त परिणाम होत असतो. तेव्हा मी सांगतो हे आता साहेबांना आणि सगळ्या न्यायमूर्तींना पटेल की ही भावना नको आहे ज्युनियर्समध्ये. त्यांनी नम्रपणाच ठेवला पाहिजे. आता माझ्या भाषणाचे मी 2 भाग करतोय. एक म्हणजे पहिलं मी मराठीत बोलणार की कोर्टामध्ये आपण आर्ग्यू करताना किंवा वावरताना आपला मॅनरिझम काय पाहिजे ते मी मराठीत सांगणार आहे. कारण मनापासून जे मला बोलायचं आहे ते मातृभाषेत जितकं चांगलं मी सांगू शकेन तितकं कृत्रिमरित्या इंग्लिशमध्ये सांगू शकणार नाही. इंग्लिशमध्ये लिगल प्रोव्हिजन्सबद्दल सांगणार आहे थोडंसं, हायकोर्टाची अपेलेट साईड काय आहे म्हणून. जे मुद्दे सोनक साहेबांनी आपल्या भाषणात कव्हर केले आहेत, पण मी जरा निराळ्या प्रकारे तुम्हाला सांगीन. आता पहिली गोष्ट, कोर्टामध्ये आपण जेव्हा बसतो तेव्हा आपण कोर्टाची वेळ सुरू व्हायच्या आधी बसतो. न्यायमूर्ती येतात, ताबडतोब उभं राहायचं, मान द्यायचा. ते न्यायपीठ आहे. न्यायमूर्ती आपल्या जागेवर स्थानापन्न होईपर्यंत आपण बसता कामा नये. तसंच कोर्टामध्ये आपसात मोठ्याने बोलणं, कोर्टाकडे कोणतरी 2 वकील आपलं काम आर्ग्यू करतायत तर आपण आपसात बोलू नये, लक्ष द्यावं. त्या आर्ग्यू करणाऱ्या वकिलांना सुद्धा त्याची डिस्टर्बन्स होत असतो. कोर्टाच्या प्रक्रियेत सुद्धा डिस्टर्बन्स निर्माण होत असतो. तेव्हा ही पथ्य खूप पाळायची. आता आपण आर्ग्यू करताना समजा कोर्टाने आपल्याला काही प्रश्न विचारला, आपण आपली तयारी केलेली असते. आता जसं माझं झालं आहे, मी तयारी केलेली, पण हे सगळं झाल्यामुळे माझं सगळी तयारी डिस्टर्ब झाली आहे. तसं मी ठरवून आर्ग्युमेंट करायला गेलो आणि कोर्टाने काही प्रश्न विचारला, माझ्या आर्ग्युमेंटची लिंक तुटते. पण ते मी सांगू का कोर्टाला? नाही. कोर्टाकडून मला माझ्या क्लायंटला तर्कशुद्ध आर्ग्युमेंट करून काही रिझल्ट मिळवायचा आहे. तेव्हा कोर्टाने केलेल्या प्रश्नाला उत्तर देणं, पहिल्या प्रथम उत्तर देणं हे माझं परम कर्तव्य आहे. मी माझा मुद्दा पुढे रेटण्याचं थांबवायचं तिकडे, भले माझी तयारी अपसेट होऊ देत. हळूहळू तुम्हाला ही सवय होणार आर्ग्यू करता करता की कोर्टाने प्रश्न विचारला तरी आपली लिंक तुटलेली परत जोडता येते. पण कोर्टाच्या प्रश्नाला उत्तर द्यायची टाळाटाळ केली, चुकीचं उत्तर दिलं तर ते अयोग्य होईल. योग्य उत्तर देणं आणि जर उत्तर तत्क्षणी नसेल तर कोर्टाला विनंती करणं, साहेब माझ्याकडे आत्ता या प्रश्नाचं उत्तर नाही, मी तुम्हाला देऊ शकेन, मला थोडा वेळ द्या, मग मी हे उत्तर तयार करून. किंवा मग काही वेळा अगदी असा प्रश्न असतो की जो कागदांमध्ये आलेला नसतो तुमच्या अभ्यासात, क्लायंटला विचारूनच सांगावा लागतो. पण परत ह्यात दुसरी बाजू आहे. प्रत्येक प्रश्नाला जर तुम्ही क्लायंटला मागे विचारणार तर ते चालणार नाही. ती सगळी तयारी आधी करायची असते. आता दुसरी गोष्ट, कोर्टामध्ये आपण जेव्हा आर्ग्यू करतो तेव्हा आपल्या विरुद्ध बाजूचा वकील हा ब्रदर लॉयर किंवा सिस्टर लॉयर असते. आपण आपसात भांडायला तिथे जात नाही. जेव्हा आपण आर्ग्युमेंट करतो त्यावेळी काही वेळा पहिली गोष्ट आपण आपल्या प्रतिस्पर्धी वकिलाला माय लर्नेड फ्रेंड म्हणतो का? तो सन्मान देण्याचा भाग आहे. त्यावेळी असं लक्षात ठेवलं पाहिजे की तो माझा जरी प्रतिस्पर्धी माझ्या क्लायंटच्या विरुद्ध बाजू करता हजर होत असला तरी तो माझा प्रतिस्पर्धी नाही आहे. आपण एका बारचे मेंबर आहोत, जसं फॅमिली रिलेशन्स सोनक साहेबांनी सांगितले तशी, की आपण कोर्टात जरी वादविवाद केला तरी बाररूममध्ये एकत्र चहा घ्यायचा आहे, बोलायचं आहे, अबोलतेपणा येता कामा नये. आणि मग समजा जर कोर्टामध्ये काही वादविवाद व्हायचा प्रसंग आला तर एक पथ्य अगदी कडकपणे पाळायचं, आपसामध्ये बाजूच्या वकिलाशी भांडायचं नाही. जे असेल ते कोर्टाशी बोलून त्यांना रिक्वेस्ट करायची. समजा तो वारंवार अडथळे आणतोय, त्याच्या अडथळे आणण्यामध्ये प्रामाणिकपणे तो आपली बाजू मांडायला बघत असेल, त्याची टर्न येईल तेव्हा तो मांडेल ना. पण त्याचा जर तुम्हाला त्रास होत असेल आणि तुम्ही त्याच्याशी वाद घालायला गेलात तर तुमची लिंक तुटणार. कदाचित तो त्याचा प्लॅन असेल तुमची लिंक तोडण्याचा. सावध राहिलं पाहिजे. आणि सारखं मग तो डिस्टर्ब करतो म्हणून बोलत नाही राहायचं. मग कोर्ट आपल्या प्रत्येक हालचाली बघत असतं वर बसून. आपल्याला वाटत असतं त्यांचं लक्ष नाही आहे. आपण कसे बोलतो, कसे बसतोय, कसे वागतोय, हे सगळं ते मार्क करत असतात. जेव्हा कोर्टाला सुद्धा वाटतं की अरे हा फार इंटरप्ट करतोय, तेव्हा कोर्ट आपल्या मदतीला येतं. त्याच्यात रेस्क्यू इन्स्टिंक्ट असते कोर्टाची आपल्या बाजूने की अरे फार त्रास देतोय ह्याला, आता ह्याला अडवलं पाहिजे. मग कोर्ट पण सांगतं. मी तुम्हाला एक उदाहरण सांगतो. जस्टिस गाडगीळ आणि जस्टिस V.S. कोतवाल असा बेंच होता, डिव्हिजन बेंच होता. त्यांच्यापुढे अंतुलेंच्या विरुद्धच्या कामामध्ये गव्हर्नरचं सँक्शन हवं होतं, कारण ते चीफ मिनिस्टर होते. आणि ते सँक्शन मिळण्याकरता म्हणून अंतुलेंच्या विरुद्ध मला वाटतं रामदास नायकनी वगैरे कोणीतरी तो अर्ज केलेला होता. हायकोर्टात क्रिमिनल रिट पिटिशन चालू होता. तिथे अशोक सेन म्हणून खूप सिनियर वकील आलेले होते. आणि त्यावेळी माझ्या आठवणीप्रमाणे राम जेठमलानी हे त्यांच्या एवढे सिनियर तर नक्कीच नव्हते. आय वॉज जस्ट अन एंट्रंट. म्हणजे 5-6 वर्ष झाली असतील. 34 नंबरच्या कोर्टात, हायकोर्टात काम चाललेलं. जेव्हा राम जेठमलानी हे सारखे अशोक सेनना इंटरप्ट करतायत हे वरून बेंचने बघितलं. आणि शेवटी जस्टिस कोतवाल म्हणाले, मिस्टर जेठमलानी, वाय आर यू इंटरप्टिंग हिम, लेट हिम आर्ग्यू हिज ओन केस. त्यावर अशोक सेन थांबले. ते म्हणाले, मिलॉर्ड्स, वेन आय एंटर्ड दिस प्रोफेशन माइन वॉज अ स्किन. नाजूक चामडी होती माझी. नाव इट हॅज बिकम हाईड. कातडी झाली आहे त्याची. मला ह्याचा काय फरक पडत नाही. त्यांनी तक्रार न करता कोर्ट गेलं त्यांच्या रेस्क्यूला की अरे का इंटरप्ट करताय, करू दे ना त्यांना आर्ग्युमेंट. हे लक्षात ठेवा. त्यामुळे इंटरप्शन्स ही टॉलरेट करता आली पाहिजेत. आपला अभ्यास जर चांगला असेल तर त्या इंटरप्शन्सचा आपल्या आर्ग्युमेंट्सवर काय विपरीत परिणाम होऊ शकणार नाही. हा महत्त्वाचा मुद्दा लक्षात ठेवा. आता दुसरी गोष्ट, आता मी लिहिलेलं वाचतच नाही, आता सांगतोच. आता दुसरी गोष्ट एक सांगण्यासारखी आहे की जेव्हा कोर्ट एखादं, काही वेळा कोर्टसुद्धा एखादा हलका फुलका रिमार्क करतं. ते सुद्धा सोनक साहेबांनी सांगितलं तर ते सुद्धा ह्युमन बिईंग्ज आहेत. त्यांनाही वाटतं काही वेळा हलकं फुलकं काहीतरी बोलावं. आपण ज्युनियर आहोत, मला तुमच्यातलाच समजतो आहे. आपण ज्युनियर आहोत. आपण त्याच्यावर सोनक साहेबांनी सांगितलं रिटॉर्ट करता कामा नये. याचं कारण आपल्याला अजून आपल्या क्षमतेचा, आपल्या कॅपॅसिटीचा अंदाज आलेला नाही. आपण ते त्याच्याशी एक्सेस होऊ शकतं आपल्या बोलण्यातून. तेव्हा रिटॉर्ट कधीही करायचा नाही. कोर्टाने सांगितलं आपण त्याच्यावर शांत बसायचं. रिटॉर्ट करण्याचा मोह असतो, तो मोह सिनियर्सनी करावा. मी अजून केलेलं नाही हां, सिनियर्सनी करावा. आता तुम्हाला एक उदाहरण सांगतो, इंटरेस्टिंग आहे, घडलेली घटना आहे. एक मोठं क्रिमिनल केसचं एक मोठं प्रकरण हायकोर्टात झालं. साधारणपणे 1975च्या दरम्यान असावं. लँड ॲक्विशनच्या केसेसमध्ये हायकोर्टाने जी फायनल फर्स्ट अपिलातली जजमेंट्स दिली त्याच्या ज्या डिक्रीज होतात त्या डिक्रीमध्ये इंटरपोलेशन झाली अमाऊंट्सची आणि प्रचंड मोठ्या अमाऊंट्स दिल्या गेल्या. मग हायकोर्टातले काही स्टाफ, गव्हर्नमेंट प्लीडरचा स्टाफ आणि त्यातला एक मेन ॲक्युज्ड होता, ॲक्युज नंबर 1, त्याचं नाव नाही सांगत, ते लँड ॲक्विशनच्या केसेस घेऊन यायचे आणि हायकोर्टात दाखल करायला द्यायचे वकिलांकडे. तर त्याच्यात ते गावोगावी जायचे आणि शेतकऱ्यांना संबोधित करायचे की तुम्हाला मी ॲक्विजिशनमध्ये जास्त कॉम्पेन्सेशन मिळवून देईन. आणि त्यांनी असं सांगितलं, त्यांची पत्र रेकॉर्ड आली 1-2 की मला हायकोर्टामध्ये बॅकडोअर एंट्री आहे. आणि मग त्यांनी काही त्यावेळच्या खूप म्हणजे 50 वर्षापूर्वीच्या काही 1-2 जजेसची नावं लिहिलेली पत्रात XYZ. आता ते पत्र आलं एव्हिडन्समध्ये, त्याच्यात त्यांना कन्व्हिक्शन झालं आणि जस्टिस मोहरीर यांच्या पुढे. आणि सिनियर वकील अपेलेंट करता आर्ग्यू करत होते. जेव्हा ह्या पत्राचं वाचन झालं तेव्हा जस्टिस दाऊद म्हणाले, मिस्टर, व्हॉट इज दिस? युअर क्लायंट हॅज सेड दॅट ही हॅज बॅकडोअर एंट्री इन द हायकोर्ट. आता बघा, हा रिटॉर्ट नव्हता, पण आन्सर बघा कसं होतं. त्याला खूप तपश्चर्या लागते, असं आन्सर द्यायला जाऊ नका, मी तुम्हाला कॉशन करतोय. त्यांनी आन्सर असं दिलं, साहेब माझ्या क्लायंटचं काय चुकलं? अहो साहेब, तुम्ही ज्या दरवाजाने हायकोर्टात येता ती फ्रंट एंट्री आहे. ॲडव्होकेट्स आणि क्लायंट्स ज्या दरवाजाने येतात ती बॅकडोअर आहे. माझ्या क्लायंटचं काय चुकलं? बॅकडोअर एंट्री. आम्ही बाजूने जातो ना, मागच्या बाजूने जातो. ती मागची बाजू आहे, ही पुढची बाजू आहे. आणि तो विषय तिथे मिटला. वास्तविक हे फार ग्रॅव्हिटी होती या पत्राची, भयानक. आणि नंतर त्यांना इतर गोष्टींवर ॲक्विटल पण मिळालं, तो भाग निराळा. पण रिटॉर्ट करायचा नाही. आपण रिस्पेक्टफुल वागलं पाहिजे. हे सगळं ठीक आहे, हलकं फुलकं वातावरण वगैरे आपण नाही ठेवायला जायचं, साहेबांनी ठेवावं. आता महत्त्वाची गोष्ट की बघा, मी तुम्हाला सांगतोय, काही लोकांना आवडणार नाही किंवा पटणार नाही. माझ्या मते वकील आर्ग्यू करताना त्याने दोन्ही हात समोर ठेवावेत. आता बघा, मी जर असं भाषण करत राहिलो, धरून चाला, कसं दिसेल हो? साहेबांच्या पुढे वी मस्ट बी रिस्पेक्टफुल. साहेब, दिस इज माय केस. अरे असं नाही करायचं. आपण ज्युनियर आहोत, सिनियर करत असतील कोणीतरी, आपण नाही करायचं. दोन्ही हात समोर ठेवायचे आणि वेळप्रसंगी थोडंसं हालचाल दोन्ही हातांची झाली तरी चालेल, पण हात बांधून बरं नाही दिसत. हां, तर ते तसं करू नका. अगदी कटाक्षाने हे टाळा. आता मगाशी सांगितलं त्याप्रमाणे विरुद्ध बाजूच्या वकिलांवर आरडाओरड करत धावून जाणं, त्यांना व्यक्तिगत गोष्टी बोलणं, हे बरोबर नाही. मला एक असा अनुभव आहे, मी तुम्हाला सांगतो. मला वाईट वाटलेलं खूप. एक सिनियर वकील होते, त्यांची फी मोठी असायची. एका ज्युनियरने दोन वेळा त्याचा उल्लेख कोर्टासमोर केला की यांचा क्लायंट कसा गरीब असेल, त्यांनी हे भरपूर फी घेतात, आपला संबंध नाही. तार्किक युक्तिवाद करणं हे आपलं काम. ते करायचं असेल तर तुम्ही भरपूर कष्ट करून आपल्या कामाची तयारी केली पाहिजे. आता एक महत्त्वाचा मुद्दा मी तुम्हाला सांगतो. हे बघा, तुम्हाला मी एक उदाहरण देतो की मी नंतर परत तो पॉईंट परत सांगणार आहे निराळ्या कॉन्टेक्स्टमध्ये. कष्ट करण्याकरता लिमिट नाही. जसं आपण वाचलं आहे की वन्स अ मॉर्गेज ऑलवेज अ मॉर्गेज, तसं वन्स अ लॉयर ऑलवेज अ लॉयर. एव्हरी मोमेंट ऑफ युअर लाईफ यू आर अ लॉयर. यू कांट फॉरगेट दॅट. आपण जे वागतो, मगाशी सांगितलं त्याप्रमाणे, आपण जी कोर्टात हालचाल करतो, आपल्या डिमिनरवर कोर्टाचं न्यायमूर्तींचं लक्ष असतं, त्यांच्या लक्षात येत असतं. ते सांगणार कशाला तुम्हाला वर बसून असं करू नका म्हणून. तसंच आपल्या वागण्यावर समाजाचं लक्ष असतं आणि ही आपल्यावर जास्त जबाबदारी आहे की आपण व्यवस्थित वागलं पाहिजे. मग समाजावर त्याचा परिणाम होत असतो. संस्कृतमध्ये वाक्य आहे, महाजनो येन गतस्स पंथाः. मोठे लोक ज्या मार्गाने जातात तो मार्ग सामान्य माणूस फॉलो करत असतो. तेव्हा आपण लक्षात ठेवलं पाहिजे की आपलं वागणं हे एक्झम्पलरी पाहिजे. ते कसं ठेवायचं, त्याच्यासाठी एक आणि एकच मार्ग आहे, भरपूर कष्ट करणं, आपलं ब्रीफ नीट वाचणं, आपल्या ब्रीफवर भरपूर वेळ विचार करणं, मननचिंतन हा एक महत्त्वाचा भाग आहे. आणि अभ्यास म्हणजे काय? अभ्यास हा मूळ शब्द संस्कृतमधला आहे, अभि अधिक ई. ई हे व्हर्ब आहे इंग्लिशमध्ये, ज्याला वर्ब म्हणतात तसं क्रियापद. ई म्हणजे रिसाईट करणं, आणि अभि अधिक ई अभ्यास ज्याच्यावरून झाला आहे त्याचा अर्थ आहे पुन्हा पुन्हा रिसाईट करणं. आता हे रिसाईट का? पूर्वी पठणाची पद्धत होती म्हणून. आता तुम्ही वाचलं पाहिजे, परत परत वाचलं पाहिजे, आणि परत परत वाचण्याचं तुमच्या मनावर महत्त्व बिंबावं म्हणून मी तुम्हाला आता एक अत्यंत सुंदर उदाहरण देतो. आपण सगळे लहान असताना आपले आई वडील आपलं कौतुक करायचे, आपल्याला जवळ घ्यायचे, आपले मुके घ्यायचे. संध्याकाळी नोकरीवरून वडील घरी आले की आपण त्यांच्याकडे जात होतो, ते आपल्याला कुरवाळायचे. आता त्यांचा काय हा प्रेम करणं, आपल्या बाळाचे मुके घेणं, त्याला कुरवाळणं हा काय साप्ताहिक किंवा पाक्षिक कार्यक्रम होता का? रोजचा होता. तसं आपलं ब्रीफ हे आपलं बाळ समजून तुम्ही त्याचे लाड करा, त्याचं कोड कौतुक पुरवा, ते भरपूर वेळा वाचा. जसं सोनक साहेबांनी सांगितलं 5 वेळा 10 वेळा वाचा. ते पुन्हा पुन्हा वाचल्याने तुमच्या आकलनात फरक पडतो. ह्याचं कारण आज मी जे ब्रीफ वाचलं ते पुढच्या 8 दिवसात मी कोर्टामध्ये काहीतरी दुसऱ्यांच्या आर्ग्युमेंट्स ऐकताना माझ्या कानावरून काही विचार केलेले असतात, काही जजमेंट आलेली असतात सुप्रीम कोर्टची, हायकोर्टची नवीन, ती मी वाचली पाहिजेत. ती मी वाचून माझ्या आधी वाचलेल्या कामाच्या फॅक्ट्समध्ये मला काहीतरी निराळा एखादा मुद्दा सापडतो. आणि मग जसं आपलं कोड कौतुक करणाऱ्या आईवडिलांना आपण त्याचा प्रतिसाद म्हणून त्यांना प्रेम देतो, तसं हे ब्रीफ तुम्हाला त्याचे रिटर्न्स देणार, भरपूर रिटर्न्स देणार. मला अनुभव आहे हा, मी हे स्वतःच्या अनुभवावरून सांगतोय. हे कुठच्याही पुस्तकामध्ये तुम्हाला मिळणार नाही असं मला वाटतं. तुम्ही जितक्या वेळा त्या ब्रीफवर, आता माझे मित्र काही माझी गंमत करतात की मी मार्किंग करतो, त्यावेळी ज्या रंगाचा पेन माझ्या हातात असतं त्या पेनने मी मार्किंग करतो. मग काही निळं मार्किंग असतं, काही काळं असतं. विशेषतः माझे ज्येष्ठ वकील जहागीरदार साहेब आहेत, ते नेहमी माझी गंमत करतात, अरे काय तुला कळतं आहे का कुठचे मार्क कुठे आहेत, काय आहेत वगैरे. हो मला कळतात, कारण मी ते परत परत वाचतो, त्यामुळे फरक पडतो. आणि शेवटी महत्त्वाचं लक्षात ठेवा, आपण जे कोर्टात आर्ग्यू करायला उभं राहतो ना, तेव्हा हा जो आपला वाचन केल्याचा अनुभव असतो ना, त्याने तुमचा आत्मविश्वास वाढतो. नुसतं मी म्हणेन जा कॉन्फिडन्सने आर्ग्यू करावं, तो कॉन्फिडन्स कसा येणार? तो कॉन्फिडन्स या अभ्यासाने येतो. जसं अभ्यास केल्यावर परीक्षेत पेपर चांगला लिहायला मिळतो, लिहिणं शक्य होतं, हा पेपर आहे, आपली परीक्षा रोज असते. तेव्हा हे कष्ट करण्याची तयारी ठेवली तर तुम्हाला यश निश्चित मिळणार. यश मिळायला कष्टाला पर्याय नाही. आणि तुम्ही कष्ट केलेत, चांगली तयारी केलीत, तर तुम्हाला परमेश्वर किंवा दैव, त्याला जे काही म्हणाल ते, त्याकडे तुम्हाला यश देण्याला पर्याय उरत नाही. हे लक्षात ठेवा. कष्टाला पर्याय नाही, आणि कष्ट केले तर तुमच्या यशाला कोणाला पर्याय ठेवता येत नाही, तुम्हाला यश मिळणारच. आणि बघा, एखाद्या केसमध्ये यश नाही मिळालं, त्यामुळे नाउमेद होता कामा नये. नाउमेद झालात की गेलं सगळं. उमेद कायम राहिली पाहिजे. आणि माझं तर मत आहे की भगवद्गीतेत जे सांगितलं आहे, कर्मण्येवाधिकारस्ते मा फलेषु कदाचन, ती भगवद्गीता वकिलांसाठीच लिहिली गेली आहे. तुम्ही तुमचं काम करा, यश मिळणं न मिळणं हे नंतरच आहे. आणि यश मिळणं न मिळणं जया सुखदुःखे समे कृत्वा लाभालाभौ जया जयो. सुख आणि दुःख हे सारखं मानून आपण काम करत राहिलं पाहिजे. आणि तुम्हाला एक माझा अनुभव सांगतो. मी ज्युनियर असताना खूप खट्टू होत असे, वाईट वाटत असे. एविक्शनच्या डिक्री विरुद्ध आलेल्या रिट पिटिशन डिसमिस झाल्यानंतर क्लायंट घराबाहेर पडणार म्हटल्यावर मला वाईट वाटत असे. मॅट्रिमोनियल केसमध्ये कस्टडी आपल्या क्लायंटकडून आईकडून वडिलांकडे, वडिलांकडून आईकडे दिली की मी रडत असे. पण हळूहळू काय व्हायला लागलं, आधीची स्किन होती, आता हाईड व्हायला लागली. आणि दुसरं की हे सगळं जे आहे ना, ते हळूहळू तुम्ही जसे बिझी होत जाल ना, तसं तुम्हाला एका केसमध्ये मिळालेलं यश त्याचा आनंद घ्यायला वेळ नसणार, कारण तुमची दुसरी केस दुसऱ्या कोर्टात निघत असणार. एका कोर्टात हरलेल्या केसचं दुःख करायला वेळ नसणार, कारण पुढची केस दुसऱ्या कोर्टात निघत असणार. हा आता आपला प्रोफेशनल हॅझर्ड आहे, त्याला इलाज नाही. तुम्हाला तो इलाज ठेवलेला नाही. आपण आपलं काम करत राहायचं, त्यातून अनुभव येत जाणार, कॉन्फिडन्स वाढणार कष्ट केल्यावर, आणि तुम्हाला यश आपोआप मिळणार. सोनक साहेबांनी तुमच्यापैकी बऱ्याचशा जणांच्या मनामध्ये आता बीज रुजलेलं असणार की पुढे ज्युडिशियल अपॉइंटमेंटची ऑफर आली तर नाही म्हणू नका. पण ते बीज आता अंकुरायला लागलं आहे, त्याची निगा राखा. ते वाढणार आहे, ते नीट वाढायला द्या, त्याची जोपासना करा, त्याचा प्रोटेक्शन करा, त्याच्या आजूबाजूला कुंपण घाला कष्ट करण्याचं. तर ते बीज चांगलं मजबूत रोप म्हणून पुढे वाढणार आहे, हे लक्षात ठेवा. आता हा बराचसा पहिला भाग माझा कवर होत आलेला आहे. हां, आता एक महत्त्वाचा मुद्दा, तोही सोनक साहेबांनी सांगितला आहे की हा वकील खोटं बोलतोय किंवा चुकीचं बोलतोय, हे कोर्टाचं इम्प्रेशन जर आपल्याबद्दल झालं तर पुढच्या एखाद्या डिझर्विंग केसमध्ये एखादा न्यायमूर्ती म्हणाले, अरे हा चुकीचं आणि खोटं बोलणारा आहे, हा हे खरं कशावरून सांगतो. आता हा रंग आपल्याला लागायला देता कामा नये. हे बघा, मी तुम्हाला सांगतो, लक्षात ठेवा, वकिली हे व्रत स्वीकारून काम करण्याचा व्यवसाय आहे. वकिली हे काचेचं भांडं आहे, काचेचं भांडं. काचेच्या भांड्याला एवढासा जरी तडा गेला ना तरी आत पाणी टिकत नाही, ते युजलेस होतं, भांडं फेकून द्यावं लागतं. तसा वकिलीचा व्यवसाय आहे, त्याला इतका सुद्धा तडा जायला देऊ नका, खूप काळजी घ्या. मगाशी सांगितलं त्याप्रमाणे आपल्याला कोर्टाच्या क्वेरीला उत्तर नसेल तर कोर्टाला सांगा, साहेब माझ्याकडे आत्ता उत्तर नाही, मला थोडी सवड द्या. पण आपल्या क्लायंटच्या बाजूने कोर्ट आहे, मग आपल्याला आत्ता थोडंसं खोटं बोललं तर रिझल्ट मिळू शकेल. क्लायंटला रिझल्ट मिळेल, पण तुमची प्रतिमा जर डागाळली गेली ना, येणार नाही. तुम्हाला कितीही यश मिळू देत नंतर. मी असे पाहिले आहेत आजूबाजूला लोक की जे यशस्वी वकील म्हणून आहेत, जे खूप पैसे मिळवतात, जे मानमरातब मिळवतात, पण कुठेतरी ते राहून गेलेलं आहे की हे सगळं खरं सांगत नाही, ते थोडंसं खोटं बोलतात. का म्हणून, कशाला म्हणून व्हायला पाहिजे. निर्मळ यश मिळवण्याचा प्रयत्न करा, ते मिळणार, कुठेही जाणार नाही. पण हे व्रत पाळा. आता आणखीन एक महत्त्वाचा मुद्दा यामध्ये, मगाशी मी सांगितलं आहे की आपसात बोलायचं नाही, आपसात आर्ग्युमेंट करायची नाहीत, आपसात एकमेकाच्या अंगावर जायचं नाही. आणि जे कोर्टात होईल ना ते बारमध्ये गेल्यावर विसरायचं. बार म्हणजे बाररूम. आणि मला असा अनुभव आहे की मी ज्या टेबलवर बसतो त्या टेबलवर बऱ्याच कोर्टातले जजीस वाद झाला की सांगतात, जा त्या टेबलवर जाऊन चहा कॉफी घ्या. कारण ते खरं लाईफ आहे आपलं. कोर्टातला वादविवाद हा बाररूममध्ये नेऊ नका. मी तुम्हाला एक अत्यंत अनप्लेझंट असा म्हणजे अनुभव माझा आहे, जो मी आता नावं घेऊन सांगत नाही, परंतु 2 वकील सिनियर चांगले अतिशय बिझी एका टेबलवर बसत असत जेवणाला. त्यांची कोर्टात खूप भांडणं व्हायची, बरीच, म्हणजे बऱ्याच केसेसमध्ये ते एकमेकांच्या विरुद्ध असायचे. शेवटी ती भांडणं इतकी विकोपाला गेली की त्यातला जो ज्युनियर होता ना, ज्युनियर वकील, जो स्वतः नंतर ते दोघंही हायकोर्ट जज झाले, ज्युनियर वकिलाने आपलं लंच टेबल बदललं, दुसऱ्या टेबलवर जाऊन ते बसायला लागले. आम्हाला वाईट वाटलं, आम्ही ज्युनियर होतो त्यावेळी, वाईट वाटलं. आणि त्यातून धडा घेतला की काहीही झालं, कितीही जरी वादविवाद कोर्टात झाले तरी ते बाररूमपर्यंत येता कामा नयेत. एवढी काळजी आपण घेतली पाहिजे, ते आपलं कर्तव्य आहे. आता मी तुम्हाला आपला वकील म्हणून, अपेलेट साईडचा वकील म्हणून काही हिंट्स देतो, फार वेळ घेत नाही, हिंट्स देतो. एक म्हणजे आपल्याला सिव्हिल प्रोसिजर कोड, एव्हिडन्स ॲक्ट आणि लिमिटेशन ॲक्ट, ट्रान्सफर ऑफ प्रॉपर्टी ॲक्ट, कॉन्ट्रॅक्ट ॲक्ट, हे 5 अतिशय चांगले अभ्यासले पाहिजेत. आणि ह्यात सगळ्या बेसिक कन्सेप्ट्स आहेत. ट्रान्सफर ऑफ प्रॉपर्टी ॲक्ट, कॉन्ट्रॅक्ट ॲक्ट, लिमिटेशन ॲक्ट, ह्यात बेसिक कन्सेप्ट्स आहेत. सिव्हिल प्रोसिजर कोड हे बरंचसं प्रोसिजरल आहे, त्याचा अभ्यास तर अत्यावश्यक आहे. म्हणजे मला असं आठवतं, माझ्या आजोबांनी सांगितलेलं की जेशी शहा म्हणून जे नंतर चीफ जस्टिस झाले, ते प्रत्येक सुटीत लायब्ररीत येऊन बसायचे हायकोर्टाच्या आणि CPC पहिल्यापासून शेवटपर्यंत परत वाचायचे. पण तेवढा आपल्याला मिळणार नाही वेळ. आपण ज्युनियर आहोत, आपल्याला गृहकृत्य आहेत, आपल्याला फॅमिली आहे, आपल्याला झगडावं लागतं आहे, कष्ट करावे लागत आहेत. पण जेव्हा शक्य होईल तेव्हा सिव्हिल प्रोसिजर कोड परत वाचत चला. त्याचे काय फायदे आहेत ते मी तुम्हाला पटापट सांगणार. आता ह्याचे परत मी 2 भाग केले आहेत. एक म्हणजे प्रोसिजर तुम्हाला सांगतो, कारण आता कोर्टात काय करायचं ते सब झालं, ते मॅनर्स वगैरे. आता ह्याचे 2 भाग आहेत. एक म्हणजे प्रोसिजरचे आणि दुसरं, नाव आय विल स्विच ओव्हर टू इंग्लिश. Another aspect is how to treat the client, how to discuss with him. As Justice Sonak had said, client, you have conference with the client. Now many lawyers will feel that while filing appeal or arguing appeal, why do we need the client's presence or discussion? We don't need it. All evidence is laid in the trial court. All documents are produced. It is very important. I'll tell you the reasons one by one. Firstly, treat that client. I'll give you an illustration of Bhangarwala. The one who runs a shop of collecting, sifting the trash material which is brought to him by the rack pickers. He sifts the material. He separates absolute trash and copper, iron, or some such things. Now, if he can make money out of it, so much so with the discussion in office with the client. Client has wonderful store of facts. It may be that he has not been able to place it before the trial court lawyer, or the trial court lawyer was not careful enough to collect that material from him, for want of experience or whatever you call it. He will give you many facts which you will find relevant, and then Order 41 Rule 27 will come to your aid, additional evidence in appeal court. Then you can advise him to file that application by making out a case, by proper pleading that this evidence could not be produced in the lower court. So, if you spend time with your client, you will be more competent to argue his case before the court, because you have now all the relevant facts before you. Secondly, study the Roznama of the lower court very carefully. The importance of Roznama is immense in this profession. What we call Nadi, pulse of the body. If you study the Roznama carefully, you will know the health of the matter, condition of the health of your matter in the higher court. I found in one matter, and many matters are there of similar kind, I found that appeal court had relied on a document in first appeal, lower court, first appeal, district court appeal, where that document was produced across the bar, it was accepted by the judge and relied upon against my client, without any application under 4127. I pointed it out to the court. I pointed it out to my colleague who argued that case because I was unable to appear on that particular occasion. Now see how I benefited. Because I studied Roznama. Study Roznama, correlate the exhibits, how the exhibit has come on record, whether it is proved, it is not proved, or simply, otherwise it may have been admitted by your client. But find it out. If you try to find it out, you will get many hints to argue your case. This is one. Now, secondly, there is one provision which is very useful. Under relevant order, I will tell you the order. Notice to produce has to be given. Now, that is Order 11, Rule 16, read with Form 7 of Appendix C to the Civil Procedure Code. Notice to produce. You will find that some important document is withheld from the court by the opponent. I have used it in 2 cases with great advantage to my client. In one BMC case, I was appearing. The person had constructed unauthorized structure. He had not produced the sale deed of his property in the lower court. Sale deed, if he had produced, there was a description there is to be description of the property in the sale deed. He withheld it from the court. I obtained certified copy. I kept it with myself. I found that though he had pleaded in the plaint that there was FSI available and there was additional construction, I found, fortunately for me, in that sale deed, there were recitals that all FSI is already exhausted. I gave notice of production under this particular provision, and other side had to produce it. And if he had not produced, I would have produced my copy and persuaded the judge that this is so. But the adverse inference has to be drawn if such notice is given previously. Otherwise, adverse inference is a vague principle. It is to be practiced in the manner in which Civil Procedure Code provides. So that you remember. Then there is another provision which is a magical wand in the hands of the High Court. Order 41, Rule 33. The order which trial court would have passed or ought to have passed in the interest of justice, you can apply to the High Court while getting a judgment in your favor that give this further direction under 4133. Now, I will tell you in short the provisions relevant to appellate side practice. My Lord Justice Sonak has exhaustively told you about 226, 227. He has summarized it wonderfully. I found that my learned friend, Mr. Anil Sakhare, learned friend not in the sense of opponent, my friend Anil Sakhare has delivered a lecture on appellate side practice. I saw that he has extensively dealt with this, but I found that Justice Sonak's elucidation is very succinct and very useful. He has touched every aspect in such a short time. Now I will not touch it again. That will be a separate matter. The main provisions of appellate side. The appellate jurisdiction flows from section 96, read with order 41. I'll tell you, you may note down. Section 96 to 99 are provisions of first appeals in the Civil Procedure Code, and section 100 to 103 provisions of second appeals means appeals against appellate decrees. There is no term second appeal there. Appeals against appellate decrees means the decree of the first appeal is to be challenged by way of second appeal. Sections 100 to 103, substantial question has to be formulated and all that, read with order 42. And if you see rule 1 of the order 42, you will find that as far as possible, the provisions of order 41 are made applicable. Now there is one important section, 94, you just note it down, I will tell you the importance. Now, after second appeal, there is the provision of revision. And my Lord Justice Sonak has made reference to it. Whenever there is no appeal available, no remedy. No remedy available is 226, 227. But when there is no appeal provided, the High Court can exercise revisional jurisdiction. There are ingredients of power, and the first is the exercise of jurisdiction not vested, non-exercise of jurisdiction vested in it, or exercise of jurisdiction with material illegality and irregularity. Now third one is very important, study case law under that. That will give you good help. And now with this, then there is a provision of review. Now about section 94. 94 is the source of power of injunction, power of receiver. Order 40 relates to receiver. Order 43 relates to appeals from orders. It says that appeal will lie against the following orders and not against any other orders. Now appeal is a creation of statute. Unless it is provided, it is not available. Now I am going to give you a case which is very important, and this has importance from the point of view of your advice to your clients about choice of remedy. Choice of remedy is the first thing which we juniors must be able to give with able advice. Now I will tell you this case and I will explain to you in short, then nothing more remains to be said. This is a case reported in AIR 1994, Bombay, page 38. It is delivered by Justice V.P. Tipnis. And the name of the parties is Hari Vilas versus Viraf Ardeshir. You can find out from the citation. I will tell you the facts in brief. Under Order 39, Rule 11, there is a power given to the High Court to take cognizance of contempt of court by violation of its own orders. Any court, injunction is given, violated by the defendant, plaintiff can apply to the court. There may be similar order against the plaintiff in favor of the defendant. If plaintiff violates, then different consequences follow. Now, Order 43 Rule R provides for appeal against order under section 13, Order 39, Rule 1, 2, 2A and 4. Now this is central provision. In the Central Act of CPC, that is also again very important point. You have to have Maharashtra amendments of the Civil Procedure Code, that copy of Civil Procedure Code which will contain Maharashtra amendments. The most dangerous thing happened in the earlier case which Justice Tipnis had to set right. Now, in Maharashtra amendment, this Order 2A is omitted, was omitted in the past. So no appeal would lie against an order under Order 39 Rule 2A. And a case came before our High Court earlier, which is a case reported in 1993, one Bombay Cases Reporter 131. There was a finding of contempt against the defendant. Appeal was filed and objection was raised that appeal is not maintainable because under 43 Rule 1R, 2A is omitted in Maharashtra amendment. The appeal was dismissed. Then the question came in subsequent case before Justice Tipnis. And now here is very important point, which while we were traveling from station to this hotel, Santosh Shah advocate mentioned to me, very important. Section is very important. Rules are given as a modality to operate. So now Justice Tipnis considered Section 94, and there certain types of orders in contempt giving punishment to the party are specified. And the case in which earlier judgment was given that appeal is not maintainable was in ignorance or per incuriam, and it was given without considering that section. So Justice Tipnis in a very lucid manner discussed it and said that because there was an appeal under the main section, omission of that Rule 2A from Order 43 Rule 1R was immaterial. So that is how, and now I find, as my son who is a lawyer, when we were discussing, he pointed out that in 2009 that 2A is amended and added, because by way of abundant caution perhaps. So this gives us a very important warning that you as junior lawyers must be very careful judgment and finding out the remedy in the High Court in appellate side jurisdiction. As Justice Sonak mentioned that if second appeals are provided, now see the order provided, Order 42 and section also. In section it is said, perhaps 103, that for if the value of the subject matter is up to 25,000, no second appeal would lie. And now here you will find in a dispute, a small piece of land may have been involved of which valuation is below 25. Yet second appeal lies because it relates to immovable property. But where the monetary value of subject matter, not land, say commercial dispute, etc., is below 25,000, second appeal does not lie. Then what would lie? Now you tell me, if no appeal is provided, what would be the remedy in High Court? Revision under 115. And in certain cases, if the revision is also barred, then writ petition under 227. Get my point? So you must first find out whether appeal is a remedy. If no appeal, whether revision lies. Whether revision is prohibited, then writ. This is a great responsibility cast on us. I am appealing to you. I am entreating all juniors to study this aspect very carefully. If you pursue wrong remedy, like in that judgment of contempt of court, perhaps the fellow was doomed because of the... And appeal was filed rightly. Appeal was filed rightly, perhaps by looking at the central legislation of Civil Procedure Code. But a lawyer could not justify it during the hearing. He could not justify. If he had seen that section, then he would have been able to point out to the court that appeal is the right remedy. Unfortunate, very unfortunate. So we must have this, you must study these provisions very carefully. And now, the last part, which I am making some emotional appeal to you juniors. Hear me carefully. As a senior lawyer experienced and having done my job with sufficient honesty and sincerity, I feel if I don't give you these personal hints, I will be lacking in my duty when I am called here to give you this lecture. 1. You study and work hard, that I have already told. Everybody has different habits of reading, when to read the briefs. Some people would like to read them late at night. Some would rise very early, read the brief. Have your own choice. I have nothing to say about that. But you have equal duty to your family. Take care that your family life is not upset because of your work. I am coming to other points also, some other reasons which disturb family life. This is first and foremost. You may work, you may read as much as you want, you may work very hard, but not at the cost of your family life. Devote time to your parents, wife, children. See now, my wife has accompanied me here. She is a part of my professional life also. Take care that you don't alienate your partner. You may have ambition to excel in this profession, but that excelling will be possible if you work hard and sincerely. You don't have to sacrifice your family life for that. Secondly, if you have good liking for reading books, reading novels, hearing music, do it. Do it. It will give you great relief from the professional stress. Every morning, if you hear 1 or 2 good songs, it makes your day pleasant. I have experienced this. 1 or 2 good songs, which of type of which you like, classical, whatever it is, or light music. Do it. And as it is said, English, you don't feel diffident because you can't speak English, but at the same time, you read good English books written by English authors, story books, novels, and in any event, good judgments written by the High Court, our High Court and Supreme Court. Read the judgments patiently and carefully from beginning to an end, even for the sake of good English. If it is not relevant for your particular case, there are judgments which you consult your seniors. They will guide you, they will recommend to you. So, you read good English because ultimately English language will not cease to exist in court, at least in High Court and Supreme Court. I will give you an illustration. One very interesting incident. I am coming to an end of the lecture. Justice Oak, as he then was, he gave a lecture somewhere in Thana, and this happened in my presence in court next day. He gave a lecture in some Thane court or somewhere. He said that now judges must start writing orders in Marathi. There are incentives by High Court to lower judiciary if they write in Marathi, if I know correctly. Now he gave that lecture and next day he sat in court. Now there was one advocate, M.D. Angal, Madhavrao Angal. He was a simple fellow, very sincere, very honest. And he stood up when his case was called on. And he said, मेहरबान न्यायमूर्ती, मी माझा युक्तिवाद मराठीत करू का? आपण परवानगी देता का? Justice Oak said, no, not now. You now argue your case and finish with it. But English, because if you read Supreme Court judgments and High Court judgments, you will improve your English. I am giving you guarantee. Your diffidence will go away. You will become more confident. With hard and sincere work, you have already now got confidence. Advocate within you is being built. So now you must improve your English. I suffered some drawback in the initial stages because I came from Marathi medium. But I had to overcome it. My father was worried about my English. He used to tell me, you see that advocate, how he argues English. That advocate had come from English medium. But I overcame it. I read good books, and as a matter of discipline, I read them. So, do read English judgments, and don't go to English case law reports. That English is different because their laws are different, their terms are different, terminology is different. Here, our judgments are enough for you to improve English. Supreme Court and Bombay High Court. Now, there is another care which you must take as a lawyer. I forgot to mention in earlier. Don't cite overruled judgment. Now you have got the case law at the tip of your finger. Just press some software and take it out. You will get even the details of whether it is still good law or overruled. If it is overruled, it is stated there. Because overruled judgment, and with knowledge it will be worse. It will aggravate the whole thing. So take care. And now the last advice, which I am giving you in all seriousness and sincerity. Never indulge in any excesses of habits. I hope you have all understood what I am telling you. I have seen many intelligent, competent advocates being spoiled and wasted. Their talent is wasted. Their youth is wasted. Their family life gets disturbed. Your better half is, your spouse is your 50% of your advocate's job. If that gets disturbed, what is the charm in all this? What is the charm in all this? So take care that you don't spoil your family life. As my Lady Justice Deshmukh said, don't operate your mobile for any other reason except research during court hearings. Playing those quizzes or whatever it is called, even when their matter is now going to reach. Don't do it. We are juniors. Let them do. Let seniors do whatever they feel proper because they have earned it. We have yet to come up. So take care. And only one interesting case, sir, by your permission of the chair, one interesting case I must mention, where Advocate Sangram Desai is involved. Section 96 provides for first appeal. There is no provision in the Civil Procedure Code enabling a non-party person to file appeal against the decree even if it hurts him. But there is a case law, judgment of Justice Chagla, very old judgment, under Section 96, which enables a party to apply to the higher court for leave to file appeal against the order which hurts him, order or decree. Now the case which Sangram Desai had discussed with me about 25 years ago, there was a dispute of plot of land through which a road passed and the ST buses used to ply on that road. And that was the last destination where there was a village, habitation of village. School children had to go to schools. Persons had to go to the main place. In the private dispute between the two, the plaintiffs obtained an order of interim injunction against the user of the road, and that applied to ST also, state transport buses. It had completely come to a standstill. Now Sangram Desai called me. I said, don't worry, you collect some villagers, file an application for leave to file appeal. I sent him the draft which I had prepared in another matter and which I had filed and I had got the result. He filed it, and suddenly one afternoon I received a call from Sangram Desai, sir, appeal courtane injunction stay केलं. This is the power of civil procedure code and the hard study. So you bear this in mind that you have got magical wands in civil procedure code. They provide for all sorts of situations. They have collected wisdom of centuries. As it is said, amantram aksharam nasti, nasti mulam anaushadam. And the last line of that is, yojakas tatra durlabhaha. If you find nothing, no root is without medicinal qualities. No word without the power of mantra. But you must have the person who knows how to use it. So that is how you study the procedure and you will be able to give relief to your clients. And now, when you study the matter, and even if you are lost, don't worry, your preparation in that matter is the basis of your further progress. Like in Bible, Jesus Christ has said, he has given illustration of seeds. Some seeds fall in the thistles. Thistles is thorny bushes. Some seeds fall on the fertile land. Some seeds fall on a stone. In thistles, the seeds are died out. On the stone, they give sprouts, but they die out. And in fertile land, they germinate, they give you crop. So that is how, if you study hard, that work is the seed which you have sown in the fertile soil. It will give you result. Time will be taken, but it will be given to you. With all this, I think Sangram had placed the burden on my head that he called me Guru, and I had that additional burden on my head placed by him. I don't know how much I have discharged it, but I have tried to do my best. And if you all practice in the way in which I have suggested to you, I will have done my job sincerely, if not very successfully. I am thankful to my Lord Justice Sonak, my Lord Justice Karnik, my Lord Justice Bobe, Justice Chapalgaonkar was there, Justice Deshmukh was there. I thank all of them for calling me and giving me this honor, which is in recognition of my honest and sincere practice. Thank you very much.
Thank you, Advocate Walawalkar, sir, for your kind words and practical insights. I once again thank you, Lordship Justice Sri Sonak, sir, and Advocate Walawalkar, sir, for your guidance, and I am sure that your words of wisdom will be of great help to all who wish to practice in High Court. Now I request Advocate Meena Patel, Madam, to deliver a vote of thanks. If anybody has questions for the chief guest, they may raise their hand and ask their questions. You may raise your hands and ask the questions if anybody has any questions.
Sir, Good noon, sir. While practicing in the High Court, if inadvertently, please take it, sir. If inadvertently a new lawyer pronounces or refers my lordship as Your Honor, inadvertently, will it be excused?
It depends on the learned judge before whom you say it, but at the same time, we must we not take care that we now practice this, that you call them my lord or your lordship. It may happen unawares, but we must try to change our habits also. Why not? Everything is possible. Practice makes a man perfect. Practice it 10 times. Your lordship, my lord, why not?
And if by mistake, when you are practicing, hello? So when you are practicing, as our senior advocate has suggested, you call the trial court judges my lord, I'm sure they will also be delighted. But call us sir, call us whatever, don't call us names, that's all.
No, but I am telling you, then it will be a duty of the other senior advocates present in the court to quietly go behind that, pull his gown and tell him, your lordship. We do it. That has to be done by the seniors sitting aside or beside you.
Sorry, I'm talking too much, but this is always what our seniors taught us. When we were doing some mistake, they would always come behind and say that, no, do it this way. That is one thing. Second thing, what I notice, I hope you all don't mind me, but in the court, there are limited number of chairs, you are all aware. Now, we were always taught and we always practiced that whenever a senior advocate, I don't mean just designated senior advocate, we find him standing, we would always get up and see to it that they are offered the seat. So that has to be always maintained. These are some of the healthiest traditions of our bar. Right? Yes.
माझा अनुभव म्हणून सांगतो, मला असं वाटतं की आत्ता तरी आज घडीला असे कोणतेही जज आपल्या हायकोर्टात नाही आहेत निष्ठुर की ज्यांना आपण साहेब मला प्रश्न समजला नाही, परत एकदा सांगाल का, असं जर आपण रिक्वेस्ट केली तर ते रिपीट करतील. असं कोण तुम्हाला ढकलायला बसलेलं नाही आहे. कॉन्फिडन्स ठेवा. म्हणून मी सांगितलं की अभ्यास चांगला झाला की आपला कॉन्फिडन्स वाढतो. आणि बघा, कोणत्या सिनियर लॉयरने लिहिलेल्या पुस्तकात चार्ट बनवला आहे, मग ते म्हणाले की मग ब्रीफ नेण्याची गरज नाही वगैरे, तसं करू नका हो. त्यांनी सगळं करून अभ्यास करून काही सुरुवातीला ज्युनियर डेजमध्ये मार खाऊन सगळं ते मिळवलेलं आहे. तेव्हा एकदम ते करायला जाऊ नका. आपण आपला अभ्यास करत राहा, कळलं का. आणि असं काळजी करू नका. मला तरी माझा तरी अनुभव असा नाही आहे की कोणा जज, म्हणजे मी बसलेलो असताना कोणा ज्युनियरला असं जर प्रसंग आलेला असला तर आजपर्यंत मी तर असं बघितलेलं नाही कोणा जजने की त्याला धुडकावून लावलं, झिडकारून लावलं. मी एकदाच सांगणार, दुसऱ्यांदा सांगणार नाही असं नसतं. पण तुमची तयारी चांगली आहे हे कोर्टाला जाणवतं आणि कोर्ट आपल्या मदतीला येतं, ज्याला मी मगाशी रेस्क्यू इन्स्टिंक्ट म्हणून सांगितलं. ती आपल्या तयारीने निर्माण होते. म्हणून सांगितलं की जसं देवाची प्रार्थना केल्यावर देव प्रसन्न होतो तसं आहे. आपली तयारी ही आपली प्रार्थना आहे, मग न्यायदेवता प्रसन्न होते.
Good afternoon, Lordship and respected sir. My question is very kind of different to what we have discussed earlier. Like you both mentioned, each lawyer is here to argue for their clients. We are here to tell the story of our client and get your lordship's and sir's opinion on it. So my question is, when a lawyer is arguing on the case, how does he balance the passion he has for the story and the facts of the case? Because much often the time it happens that we get carried away with the passion of the story and law sometimes remains sideways. Like, how does one balance the storytelling in the aspect of passion of the story versus the case laws or the law? That's it.
That is why our art is called as practice. All right? So you have to practice it. What you ask is a very relevant question. We have all gone through it. But ultimately, legal practice is practice or training of your mind and of your expression. So therefore, try to be a little dispassionate. Try to be little less attached. In fact, Sangram will also brief us on that. He's a member of the Bar Council. They say that one of the principles of ethics is that as a lawyer, you should not be too attached to your brief. You should be dispassionate. You should be able to look at the problem from a wise person's perspective, a learned person's perspective. So controlling that passion is also necessary. Present your case firmly and fairly. The moment you present your case fairly, I'm sure the judges appreciate it. You know, one of the greatest things that a judge would really appreciate is that if you start your argument by saying that, sir, this is a fact where I have a problem, but my answers are so much ABC. Look at it from this perspective. I mean, the complete complexion of that case changes. But if you decide to argue without disclosing that fact, and then your opponent points it out, then even if you have good points and you try to make them in the rejoinder, they lose their sting. So this is the way you go about it. Sit in the court, see also, I mean, not in a bad sense, but study your judge also. Look at the manner in which he appreciates the arguments, because each judge will have his own quirks, own style. That is the way it is. Since we spoke about Fali Nariman, I had the occasion in Goa once to appear with him in a matter. And I told him that our matter is at serial number 38, so it won't come up to about 12:30 or 1. So he says, no, what time does your court start? 10:30. So he says, I would like to be in the court at 10:15. So I still tried to tell him, sir, our court is 3 minutes walk and by car we'll take a minute. So he says, no, that's not the point. I would like to sit at 10:30. No mentioning our case or priority, because I want to see what the judge would like. He was studying the judge, and that was brilliant. And the case then our board went on. Until then, there was some kind of a murmur, and after about half an hour, somebody told the bench clerk that Fali Nariman is in court. And then Justice Kamath, this was in Justice Kamath's court, who was a God's good man. So he says, oh, Mr. Fali Nariman, what brings you over here? And then he again charmed him by saying, my lords, I'll wait for my turn. And then the judge was also that way, that way. And he started his arguments also by saying that the cooperative tribunal had to constitute a full bench for this matter. So therefore, in I would feel that this is such an important matter that it requires admission. First point. Second, he said, and he also said it's a very arguable issue, so it requires admission. So he said, insofar as interim relief is concerned, for the immediate parties before us, my lords, we will stay our hands. What we are concerned with is you deciding the law. We feel that this is not a correct decision. Decide the law. We don't want to say anything. And the third request, if you can accommodate us, is for a short date. I think in 10 minutes the whole thing was over. So that's the way.
I will give you one illustration. If you are reading a horror novel, what would you do? Would you close the doors of your home? No. So passion has limit. So you take sincere interest in your client's case, but don't allow it to be transmitted to the court. That court feels that you are trying to exaggerate the case or inflate it. Take care that you don't indicate your inner thoughts to the court. But that is also again a matter of practice, as my Lord Justice Sonak has said. You will be able to do it slowly. Initially you will have to have passion in your matter, because otherwise your work will not be sincere. Get my point?
I request Meena Patel Madam to deliver the vote of thanks.
Respected dignitaries, honorable judges, learned resource persons, distinguished guests, and my dear colleagues. It is indeed my privilege to propose the vote of thanks on behalf of the Kolhapur District Bar Association and Bombay High Court Bench Action Committee Kolhapur for this valuable workshop on High Court practice and procedure. At the outset, I express our heartfelt gratitude to the Honorable Judges of the High Court, Lordship Justice M.S. Sonak Sir, Lordship Justice M.S. Karnik Sir, Ladyship Justice Sharmila Deshmukh Ma'am, Lordship Justice S.G. Chapalgaon Sir, Lordship Justice A.D. Bhabhe Sir, Respected Senior Counsel Narendra Walawalkar Sir, Principal District Judge K. Agarwal Ma'am, for their gracious presence, constant guidance and encouragement throughout this program. Their inspiring words have given us new perspective and deeper understanding. We are extremely thankful to the esteemed resource persons for sharing their vast knowledge, practical insights and experience with us. The sessions were truly enlightening and will certainly help us in our professional duties. I also take this opportunity to thank all the participants for their active involvement, thoughtful questions, and enthusiastic response, which made this program truly interactive and meaningful. With these words, I once again thank everyone for their valuable time and presence. We will end this workshop with National Anthem. I request you all, please stand up for National Anthem. Start.
पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंग विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंग तव शुभ नामे जागे तव शुभ आशीष मागे गाए तव जय गाथा जन गण मंगलदायक